Angelo showed me. I feel so stupid. It was so simple. It was
You would be my curve breaker. Congratulations. You get the book award. I'm going to go over to Anthony, where'd you go? That's so stay the same seats.
She figured out the problem.
Juanita.
Came in, present value. Interest rate.
He's a liar.
Yeah.
Blanca?
He's not the 1.3.
Alex. Alex? Owen? Sorry. Andrew? It's inefficient. It's fine. Aaron? James Carter. All the way to the back.
Well, we know it's not A.
Just didn't feel right here. First I said it's not a good idea to put your names on the front because no one knows who you are. But did everyone multiple choice? Brandon? Christina? Christina?
Not here.
Michael?
44. Renee. I didn't know that.
Simple things escape you.
Mama? Bruce. Thank you. Osler. I'm going to discuss exactly the score and stuff. Okay. I'm missing Cynthia Garcia and Christina Gibbons. If you're here, raise your hand.
Cynthia's, she's off today.
Okay.
She's not here.
See, you knew it. You just had to know yourself.
Okay. What are all the markings? The markings are what destroyed most of my week. Because I went through the exam, and I graded the exam, and I looked at how many questions were missed as a gross number, and I was very unhappy with myself. I was unhappy because a couple of things happened. Either I figured I didn't cover the material, or the questions weren't properly written. Now, I think I've told you I've written questions before for the real estate certification exam, and I'm questioning lawyers that I'm doing that. I also pre-test for that same exam now that I'm not on the committee anymore, which means I have to review questions that other people write and validate them or invalidate them. I just actually did that this past week and made a decision that I sent back. 2 of them were hyper-technical. I was going to bring them, but they would make no sense whatsoever because they were way hyper-technical. So the red number at the bottom, the minus number, is the raw score that the first time I went through it. How many questions were missed based upon the answers in the answer key. Okay? So then when I went back, I said, that's too many. Because I'm not here to give everybody crappy grades. That's not the point. I went back and I said, okay, something's not right with these questions. So I had my paralegal do a graph for me, a spreadsheet, to see, I'm telling you, this is a lot of work this week. We did a spreadsheet to see if there were questions that were missed by more than half the class. And there were some questions that were just plain flawed for one reason or another. Either because when I reread the question, I decided that there could be more than one right answer, or it was something was wrong, it was just too deep, and too many people missed it, and I just wanted to do something about it. I'm going to discuss those. Those are 9 questions like that. So if you look back at the bottom of the exams that I gave back, the plus number in blue is the ones that I added back when I invalidated the 9. And I'm going to go over which ones they were and why I invalidated them, because I want to make sure that we all understand it. The other minus number is the net number missed wrong. So, that wasn't enough for me. I decided, obviously, the people that got more of the right answers right, of all the answers right, should have a little more credit than just the ones that we invalidated and gave, okay, you could have had it right or wrong. So, the natural points per question at 45 was 2.22. What I did was, everybody that got right ones got 2.22 points per question. On the ones, if you got a wrong one validated, you got 1.75 points for that. I then added them together, total points, and that's what's up at the top. That's the methodology. What a pain in the tush. Okay, now I want to talk about the particular questions that I invalidated. Sure.
What was the exam out of?
What's
You
that?
got 50, right?
45.
45. Wait, I don't know why I did that.
Yeah, sorry.
And I will offer you 2 challenges from this side of the table. One, come up with 4 hours worth of material to talk about, because that's not easy. I thought it was going to be a lot easier. And of course, especially that last hour when you guys really do turn into zombies, because you've been here since 8 o'clock this morning listening to that. I saw the other material this morning when I came in. So, and secondly, writing the questions, writing 45 questions isn't the easiest thing in the world, because, like I said, I was trying to do it at the end of every class to stay fresh on what I talked about. I am going to tell you that based upon some of the things that I saw wrong, one of the things I would admonish you is take some notes. I see people, some people are writing copiously, some people got the computers, they're tapping, and some people are staring off into space or just listening. That's not going to work. There's no way you can listen to 4 hours of material at a time, even when I jump up and down and say this is important, if you don't take some notes. I mean, I remember what I did when I was a student, and even when I take regular continuing classes, I'm sitting there writing furiously. I had one CLE I went to, and it happened to have been given by a tax professor I had in law school. And this guy was one of the leading tax professors in the country. I was going for CLE. I didn't need to take a test or do anything with it. I never put my pen down. I sat there because it was a habit, listening to the guy, and the detail, especially the tax code, was crazy, and it was a topic I hadn't taken in school, and it was his specialty. Yes?
When you write these questions, are you involving things that other students ask? Like, if you're explaining a student's question, for example, and you're giving an example of that, are you using that as a question as well? Is that something to write down as a note?
Only if it's relating to the main topic, because some of the student questions go off topic a bit, and I'm not giving awards for that. Nor am I giving awards for turning a multiple choice test into an essay. I'm not looking at anybody in particular, but you know who you are. So the answer is no, unless that question relates to our main topic. No, and I'm going to try and push out more materials. Although the materials are really to be able to work off of, so you can see what we're talking about. The textbook is background. As I said to you, the textbook goes into much more technical detail on some of the issues. Some of it is fine. It does great stuff and really gives you a high altitude view of what we're supposed to be talking about. But for the most part, I'm trying to stay practical, because you're not in law school, you want to be in business, so the legal concepts I'm trying to stay with are to keep you on the business side of things. It's business law. it's not law school law, because if we're doing law school in real estate, we'd be talking about concepts that are boring, but they're way too technical. For example, one of the test questions that I had to evaluate for the bar thing, and remember, this is not a bar exam, this is a certification exam to certify lawyers, real estate lawyers, as specialists. It had to do with something called the Burt-Harris Act, which is a law that if the government does something in the way of its zoning and it restricts the use of the property so severely that it devalues the property, you can make a claim against the state. And first of all, it's not something that most real estate lawyers deal with. It's very technical. And secondly, there were 2 questions out of the 4, and the answers, that were identical except for one word. And it was basically something to do with what the effect on your property versus the effect on the adjacent property. And it was just way, way too technical. I really went out of my way not to write those kind of questions. That being said, let's look at the bad questions and give you an idea and tell you because, and I'll tell you what's wrong with it, and I'm going to tell you what was supposed to be right with it, and my thinking. First one is question number 5. The answer to question number 5 was all the above. But, in reality, when I think about it, probably the more common words, although I see all 3 terms, but I think what was in the contract form that I gave out to you, and what most people hear and talk about in general conversation, is a due diligence period. It is properly called an inspection period, and you see it in half the contracts I read that are typed as opposed to forms. And it's called an investigation period in some contracts. So they all do the same thing. So, but I would say most of the people that got it unright picked due diligence. And I said, okay, that's a valid answer to the question. I'm not going to take off for that. That was the first one. The next one was 19. I absolutely told you what this answer was during class. And I was really surprised. I was really surprised at the number of wrongs, but again, I didn't want, there were just too many of them, which meant that either I didn't jump up and down and yell the word enough, or you took an interpretation. I think the number 1 wrong answer was unauthorized distribution. The answer is boot. It's a technical term, and I'm fairly certain we went over it in some detail in talking about the 1031s, but again, it's technical, and I told you my methodology already. 28.
Is it technically an unauthorized?
No, it's boot.
It's boot is the term.
There's nothing unauthorized about it. So 1031 is a tax code section that allows you to defer the gain. You defer the gain by reinvesting the money, all of the money. You don't have to reinvest the money. If you, I even gave you an example. If you want to take some of the money and buy a new car, you can take the money. You take the money, you pay the tax.
Okay.
It's called boot. I said it almost those words, but again, to me the question, something was wrong with the question, too many people, and that was my way of curving it because it was just easier to do it that way. One person got only 1 question wrong naturally with no adjustments. So the curve would have helped nobody. And I congratulate that person. But so I had to come up with a more fair way to do it. That was 1928. The number 1 wrong answer was A. Complete ownership of land until death. Well, technically, that would have been a life estate if it ends on death.
Right.
But it seemed that the complete ownership part, like you would have it for as long as you had it, that's what people thought it was. I went along with it because too many people picked that and didn't pick the correct answer, which is D. Again, it's an adjustment that I... Number 30, the life estate and what happens at the end of the life estate. Don't know why, but the answer is the remainder man, it's B. Because what happens is whether you reserve the life estate to yourself and then give it to somebody else, or someone conveys a deed to A for life, remainder to B, that's what determines where it goes, not what happens to anything else. But, so again, it was invalidated for that. 33.
Doesn't the will supersede the? It doesn't?
No.
Okay, so who?
I'll tell you why. Because the will is by, you're taking by inheritance. In a life estate and a remainder remain, you're taking by purchases, the defined terms. When you create a life estate, you're actually you're giving one person the life estate, and at that point, during whoever the grantor is giving the remainder interest to another party. So it doesn't have anything to do with the will. Unless the remainder person died first, it has a whole different issue. 33. We did have a discussion about deeds, and we did discuss, because some of you who have worked with real estate and title companies, we were talking about don't give more than you get, and the quality of the deeds and so on. But any of these deeds will give good title. But the best of the deeds is the warranty deed, and a lot of people pick the warranty deed as conveying good title, which is really funny because there was another question that dealt with different kinds of deeds that was also problematic. So that was 33. Then there was 36.
So 33 was the warranty deed?
33, the correct answer is any of the above. Any deed will give good title. It's just a question of what you're warranted to be good title. 36. I can't believe how many people thought that you, as a seller, has an obligation in perpetuity to keep the property clean. I was a little surprised by that. A few of you gave the obligation to the real estate agent to keep it clean after the closing.
But that's the reality of it.
After the closing. The answer is B, merges into the deed. If you remember, the concept was the contract merges into the deed. That was the key to the whole thing.
The contract merges into the deed.
The contract goes away. It goes into the deed, and all the provisions of the contract, unless they expressly say they're going to survive, they go away. Okay? 38. I went over the different things that are in a contract that you would or would not put into a deed and why. I discussed that when a condition, you can take it back. A reservation is the right of somebody else to do something with the property. You certainly don't want a mortgage in your deed. And really the correct answer is real estate taxes. The only thing that will always be in the subject to language, because you can't do anything about it, is real estate taxes, whether it's the current year or the following year, depending upon the state, doesn't vary. The other things really shouldn't be in at all. Those are all bad words. 41. Not. That wasn't the not wasn't the problem. The problem is everybody seemed to have an issue with, and it happened in two different places. It's 41 and 42. I don't know, because I know I never said this because it's never true. People assumed that the grantee, the receiving person, had to sign the deed for some reason. And that caused a problem with both of these questions. And I'm not sure where the concept came from. Yes?
It was on one of those handouts from the book.
Acceptance is not signing. The deed has to be accepted. I gave the example of someone mailing a deed in lieu of foreclosure to the bank, saying, okay, I'm giving you this deed, I'm done with the property, I don't have to pay the mortgage anymore. That was the example that I used. And that's no good because it's not accepted. They didn't agree to take it. But if anybody has ever seen a deed, there's no place for the person receiving it to sign it. There is just you don't do it. The acceptance of it is all that's necessary. You take it and send it for recording. So in 41, that's not a requirement for the deed. So C was the correct answer there. 42, two persons hold title to the property being conveyed. Probably the number one wrong answer was D. Both persons holding title to the property, in addition to the grantee, must sign the deed. Well, the both persons holding to the title, C is correct. It's in the addition to the grantee where everybody was led astray. So that got invalidated. That's how we did it. I did it. Everybody got their names right. Congratulations. Any questions? So I'm happy to.
We gonna keep these?
That's a funny question. You know, my intention is yes. Why are you shaking your head? You want to give them back? Give them back. We're going to recycle.
Shaking your head.
Well, so here's the question. Because I asked Dr. Forgy this question. Hold on. I asked Dr. Forgy this question, and he said, if I give them to you, I can't use them again. What does that mean, recycled?
Yes, you should take it back.
I should take them back?
Is the
Hey,
file
define
gonna be
the
cumulative?
Yeah,
Uh,
that's the
sorry.
pertinent question to know if we want to keep.
We should keep these, isn't your survey?
Wait.
It's about this.
No, is it?
It's a good idea, isn't it? No, you know what? No, I'm going to say not really. I may throw. What is that? I'm a lawyer. I have to waffle. I don't want to go back and make you. I'm not going to do a 90 question final. Okay.
Okay.
I'm really, my intention was not to have it cumulative. However, that's not to say that I'm not going to throw a couple of key points back in to see if you can remember one or two basic things. Okay? I am going to try and make the questions a little less obtuse, or at least make it so that you have a little better chance at understanding what's going on. But no, the intention is not cumulative. I don't care. If you want to keep them, keep them. I'll let you guys decide. Extra credit if somebody can figure out how to make the thermostat cooler.
Did you say number 9?
What's that?
Yeah, cold, hopefully.
You did it together.
What was the question?
No, you didn't give credit for number 9, right? I didn't get it
Correct.
wrong. I had a discussion with someone
Seriously,
else.
I want to do this right, so if there's a particular question that you have an issue with, that you want to discuss and find out what's, oh, come on, number 9?
I got, listen to what I'm saying.
Go ahead.
I got it correct.
Good.
But when I went outside, I didn't recall it being discussed in class. It's just something that I remembered. And I just was like, oh, okay, I know this, but I don't recall it being discussed in the class. What did I got wrong?
Do you remember discussing incorporeal inherited events?
What, Brandon?
Call me out? Sit down.
We discussed it.
Latin and Southern accents, they just don't.
What's that?
I said Latin and Southern accents, they just.
We tuned it
I'm
out.
going to tell you something from a long time ago, and that is, you don't discount somebody because they have a Southern accent.
Well, of course not.
I had a colleague in law school, and he was from Ocala, and he had a twang, and he was one of the most eloquent people I ever worked with. So I never understood anything he said because I was listening to how beautifully he said it. But that was a problem.
That's how you win court cases, right?
Yeah, actually, that's probably a good point.
So,
Yes.
I had a question about 38.
38 was a disqualified one, but go ahead.
So,
Okay, what's your question?
no, you said it was disqualified. No,
No, what's the question? That's why I went over the disqualified ones.
Yeah, so, with real estate taxes, always, like the state always having the right of an encumbrance upon a parcel.
Correct.
Within its domain, why would a grantor?
Remember, the subject to clause in the deed takes away from your warranties. So you, as the grantor, are not warranting against whatever's in the subject to clauses. You're not warranting against plats, and things that come to the subdivision. You're not warranting against real estate taxes because you can't. So it always has to be in there.
So you can't warrant against
You
them.
can't warrant against, you can warrant that they're paid from a certain date, but you can't warrant
That's
against.
what the question was.
Okay.
Yeah.
Gemma?
So is there a different grading? Because if you do the,
The grading's at the top.
yeah, so if, when I did 5 off from 45, because I had 5 wrong, I got on the calculator 88, not 86.
Because you didn't do the math right.
Okay.
You weren't listening to my
You
formula.
did like the crazy points, you know, you got like 2.2.
So you
One
got,
point, yeah.
That, okay.
you got less credit
For the one.
for the ones with the plus. The blue plus were only worth 175. It's not a finance cost.
So you gotta go 45 times 80 something times your.
I'd show you the spreadsheet, but it's got for everybody, and that's just not, I didn't think that was the right
Who
thing.
got the 100?
What? There was no 100.
Who
There
got
was
the
one.
98?
Actually, no, it wasn't. What, Jackie?
Yeah.
13?
Yeah, I know the answer is C, which says confirm the wire instruction used a secure method. But like, what does that mean, a secure method? Like, define to me like, I guess, a secure confirmation. What is that?
Okay, so the problem with wire instructions is that you get the email or something, or a phone call or something. Email usually is where the problem comes up. And it's from your seller, you think, or your seller's title company, or somebody who says, hey, we gave you these instructions to send it to Bank of America to this account. The sellers changed their mind, they want to put it into their investment account. Can you wire it to Wells Fargo with this account number? And here's the instructions. Okay, and what happens is the email got hacked, and it's getting, the money's getting diverted to somebody whose money it isn't. So what you do is you get on the phone, and you talk to the person whose money it's going to be, or someone reliable like that, and say, hey, we got instructions that say, would you please read me what you gave me? And you let the other person read to you what you have in front of you to make sure they match up. That kind of stuff.
I have a question about the fee simple and life estate.
Which one?
The fee simple and life estate, you know, the complete right?
Yes.
I thought when you had the life estate, you didn't have the complete right.
Correct.
You had the right to stay there, but not to sell, or...
You can stay there for your lifetime. A life estate is,
So you don't have all the complete right.
you don't have anything past your, you have a complete right only during your lifetime. So that's why people got it wrong. But too
what
many,
is complete right in this case? What does that include?
beyond the life estate,
I don't know, like, if I have a life estate, what do I have the right to do with the estate?
anything but give it to somebody after you die. You can do anything you want with it during your lifetime, except give it to your nieces, nephews, heirs, children, whatever.
You say that when someone has a, like, if I had kids, I could give my property to my kids?
Not if you only have a life estate.
No, if I have the, I'm the
You-
only
if you
one,
have-
I have everything.
Fee simple,
Yes.
you could give it to your kids.
I want to put it out of my estate, so I give the property to my kids, and I say I'm gonna use it until I'm dying.
So you're keeping a life estate.
Oh, that's the right that you call the life estate, is that right, the right to stay there?
For your life. And you can do anything you want, except, unless it's an enhanced life estate, or what we call a Ladybird Deed, you can't sell it without going to your kids and saying, please, can I sell it?
Who oversees a deed like that? Like, I'm assuming something like that is given by an older person to someone, and when they die, if that person is not around and they don't have a executive of their estate, who enforces, what stops you from giving it to your kids if the person
Well,
that
because
gave
the
it to
deed's
you?
recorded, and the deed says, I'm giving my property to, usually it's to the kids, keeping an estate to myself, but you could sell it to somebody, saying, okay, here's a situation. Little old lady lives on the valuable piece that's the last key to the assemblage for a big development. And so the big developer comes and says, sell it to me, but you can live there as long as you want. The deed is going to say, deed from little old lady to big developer, saving to little old lady a life estate. So there's nobody to enforce it, it's recorded. So the only thing that needs to be done is when she passes, you have to record a copy of the death certificate to show that the life estate is ended. And because the remainder person already has the remainder interest.
What if you don't have a perpetual, if you don't have a perpetual entity that's going to enforce, like, if it's a private person to person.
Okay, so that private person then has the ownership. I sell you my house, but I keep it for my lifetime. When I die, it's yours. There's no enforcing. When I die, it's yours. The title is automatically yours. The only reason you would record my death certificate is to prove that it becomes yours.
Okay.
There's nobody to enforce.
Can you rent out a life estate?
Yes.
You can rent
Uh-huh.
it to someone.
Sure.
Okay.
You just have to hope that you don't die during it.
They have to hope.
Yeah.
The tenant.
Yeah, so if they do die, now is that like a foreclosure process? Not like, well, I guess not
Well,
because they rent it, but like, do they just kick them out, or is it kind of like they have the right to?
They could, because
They own it.
the tenancy, the
It's like they're a
rental,
landlord, so they can do whatever.
it's like sitting on the life estate.
Mhm.
So when the life estate goes poof, like any other interest that would attach to it, there's no landlord left, so there's no more tenancy. Speaking of leases, shall we move on? Yeah. Okay. So, leases. There's all kinds of different leases. I'm going to start off talking about probably the one that more of you have encountered than any other kind of leases, and that would be a residential lease. I have mastered part of Canvas, thank you for suggesting it, so I've been able to push out some documents to you, and I'm wondering whether I should bring that up to talk about or just talk a little bit first. Let me just talk about the residential leasing and things about it. So again, a residential lease is what most of you have probably encountered. You rent a house, you rent an apartment, you rent a condo. The difference between, for purposes of anything I'm discussing, I don't think I'm going to get too deep in it, but when I say an apartment versus a condo, an apartment is usually a unit in a rental building that's run by, Student Housing Inc. or Camden or one of these companies that has rental apartment buildings. All the units are rental. You could also rent somebody's individual condominium where most of your neighbors are owners and living in their units, and this one owner has it for investment, and you rent it, but it's the same concept. It's a rental, it's an apartment that's being rented. So the first thing about the residential lease that differs from most leases is that there's an approved form. And I gave you the approved form for a house lease. There is a slightly different form that's floating out there for an apartment lease, and the real difference, if you looked at it, is mostly maintenance issues, and I'll talk about that there's one particular statutory reason. So, similar to the purchase and sale contract, it's approved by the Florida Supreme Court, committees and so on, it can be completed by a non-lawyer. Now, a lease is a legal document. In order to prepare legal documents in the state of Florida, you have to have a license. Probably the only person in this room that has a license to prepare legal documents would be me, unless somebody's hiding something I don't know about. The questions would be harder. You would, you'd be fine, because you'd be trying to stump me. Okay, so basically, when it comes to a purchase and sale agreement, those of you who are in the real estate business know, you have the authority under Florida law to fill in the blanks on a contract. The contract is purchase and sale. You may also fill in the blanks on this approved form of lease. The problem that we run into in practice is that you go a little, you the real estate agents, I'm not picking on anybody, go a little bit further because you try and write in extra words in the magical additional clauses section of the contract, and that's what causes us heartburn, because they're just not written right in many cases.
That's why you source them from Westlaw.
Well, it depends, but it depends where you get them, but if they're incomplete and they say something like, subject to the sale of the property, I think I went over this, subject to the sale of the property at 123 Main Street, it doesn't say when, it doesn't say it has to be under contract, it doesn't say anything about terms and conditions, it's just a wide open condition. It may be a valid condition that would give you the right to get out of the contract, but it's ill-defined. So, all right. The approved form of lease that we're talking about cannot be for more than 1 year. Why? Anybody? Correct. Ooh, maybe there is somebody here that went to law school. But you're absolutely correct. Statute of frauds is 68901. You don't need to write that down unless you want to. I will not be on the exam. I don't do that. You will find that you will not find things, with maybe one exception, and I'm going to tell you when I get to the exception. I'm not going to ask you things like how many days do you have to wait before you do this, or what's the statute number of that, things like that. That's just, to me, that is unnecessary to take up space in your minds. You can save that for the class before.
What was her response when you said you can deem them?
Statute of frauds.
Statute of frauds.
Statute of frauds requires a conveyance of land for a term, either completely or for a term of more than 1 year, to be in writing and signed by 2 witnesses. That was another thing we talked about on the deeds that I think a few people didn't catch or missed as selected as something that's not necessary, but it is. Has to be 2 witnesses to the landlord's signature. That's for any lease in excess of 1 year. The reason for it is, going back to where I was talking about the different kinds of conveyances, it is a conveyance for a term of years. It's a conveyance, just like a deed is a conveyance. That's why it has to be in writing with 2 witnesses. The residential form of lease, one of the major features of it that you will find is it allocates maintenance obligations between landlord and tenant. You'll see all kinds of things, and usually there's also a box that'll say like half a dozen different things, but actually more, probably maybe 2 columns worth of things with a checkbox landlord and tenant. And again, I gave you this to look at. I don't know if anybody looked at it, what was posted on Canvas, but you'll see there's check marks to say who's going to do what. Residential tenancies are subject to more statutory restrictions than commercial tenancies. I also gave you, for insomnia purposes, or for some just general reference, I gave you all of Chapter 83. Chapter 83 is the landlord-tenant statute, and it's broken down into 3 different sections. Section 1 is for non-residential tenancies. Section 2 is for residential tenancies. And in Section 2, the residential tenancies, there's all kinds of things that you can't do in a residential lease, or that a residential landlord is not allowed to do. It's much more restrictive. Now, a lease does not have to be in writing if it's not for more than a year, which is, people don't realize, but you can make a deal with somebody and say, yes, sorry.
Question, the witness part, is that just for the landlord's signature, or should it be for both parties?
By law, it is just the landlord's signature.
Okay, and
because
then,
it is the landlord that is doing the conveying. Okay? So that's a technicality that most people don't focus on. However, I will tell you that if you have a lease for 5 years, it's probably a good idea to have witnesses for both. And I almost never will see a lease prepared without witnesses for both. Where the only time we will rely on it is if somebody messes up. And you'd be surprised how many times people completely ignore the fact that there's lines off to the left side that says in the presence of. There's different decoration. There's no reason to do anything with them. My lease form says 2 witnesses are required for each signature. It's right there. So if you miss it, if they miss that, they're really not paying attention.
and then the landlord law, you said Section 1 is what applies to the non-residential?
Yes, so it's part 1. The chapter is 83,
Okay.
and it's in, you have it. I gave it to everybody. Chapter 83 is the chapter of the Florida statutes. 3 sections: non-residential, residential, and self-service storage space. Sorry.
Thank you.
Okay, so if it's not in writing, it's what's called a tenancy at will. Tenancy at will means that it can be terminated by either party. The statutes give notice provisions. In a non-residential lease, I think they're probably the same. It's always dependent upon when the rent is paid and how often the rent is paid. Most of the time, you will find the agreement between the parties, even in an unwritten lease, is that you pay your rent monthly. So in a monthly lease, you have to give notice to terminate at least 15 days before the end of the rental period. Typical lease is going to start on the 1st of the month. That's what we're all accustomed to. Not required. There are many situations where a lease may start on the 15th and the rent is going to be due on the 15th of each month. It happens. It's 15 days before the end of the rental period. If it's a week-to-week lease, which is usually a more temporary kind of housing, but it does exist, you have to give 7 days notice if there's nothing in writing to terminate a tenancy in will.
Is that, are these rules all Florida rules, or this,
Florida,
just Florida?
Florida.
Okay.
But they can be more strict in terms, like, you're renting from a landlord, they say you have to give me 2 months notice.
Well, remember, those numbers that I just gave you are for an unwritten lease. It's a tenancy at will. You can do many things by contract. I don't want to say anything you want, because in a residential lease, there are certain restrictions and things you can't do. So, like I said, the residential part of the landlord-tenant statute is much more restrictive on the landlord and/or gives many more rights to the tenant. Not every state. Now, here's a difference from state to state. Some states are landlord-oriented. Florida is tenant-oriented when it comes to this.
So I'm sorry.
Go ahead.
Sorry. So the tenant can give you 15 days before they move out?
15 days before the end of the rental period.
Before the end of the rental
So if it's the 23rd of the month, you can't give notice and move out at the end of the month.
You gotta wait the next
You
month.
gotta, right.
Well, what if the landlord can't say you got 15 days to get out?
Same situation. It's reciprocal. If it's an unwritten lease, either party has the right to terminate on 15 days' notice before the end of the rental period.
And that's, like you said, that's Florida law. That's
Yes.
Florida, okay.
We don't even have habitability standards.
What's that?
I said, we don't even have habitability standards in Arkansas.
Oh, well,
It's very landlord oriented.
that's unusual. So, like I said, residential lease may not waive, this is also by statute, a residential lease may not waive any of the rights that are provided by statute. So, you know, you can't say in there, you can't write in the lease something that says, notwithstanding what's Florida law, you can do these bad things to me. And if there's something in there that the court finds to be horrible, the legal term is unconscionable, the court may refuse to enforce it. So if there's something, I don't know, can't even think of anything at the
What's the
moment.
verbiage again?
Unconscionable,
Can you spell that, please?
Unconscionable.
like conscious?
Oh, okay.
You have a conscious? Maybe you don't, but most people have a conscious. It keeps them from doing bad things. If it's something that nobody's conscious would let them do, you know, courts have kind of loose standards when it comes to this kind of stuff. Reasonableness, unconscionable. It's like the Supreme Court in the 70s, there was a case involving pornography. And the court, they were trying to find a definition as to what happened. The famous quote from one of the United States Supreme Court justices was, "I can't define pornography, but I know it when I see it." True. So a lot of these standards are really up to whatever's going on, generally. So they can't waive the rights. There's all kinds of things. Let me see, I'm going to go through. In order to protect, again, probably more the tenant, given all the things. And that is, oh, wait a minute. No, did that. Okay, it's too vague. Attorney's fees. The statute provides that the prevailing party in a civil action, which means if you have to, either of you go to court, the prevailing party gets attorney's fees. So that levels the playing field a little bit, so that if your tenant is afraid to fight the landlord in court because the landlord's got lots of property and lots of money and can hire big bad lawyers, then the tenant may not want to do that, but the tenant will have an opportunity, if they're right, to make the landlord pay for their attorney's fees. That works both ways, by the way.
Yeah, that's what I was thinking.
And I'll tell you where that works both ways when we get to the eviction things.
Is there like a reasonable standard for attorney's fees, or, I mean,
Those are the next words.
if he hires, you know, F.Lee Bailey?
They recover reasonable attorney's fees and court costs. Well, okay, it's a good point to talk about. What is reasonable attorney's fees? So, given any case, whether it's a mortgage foreclosure, regular litigation, a tenant eviction, the burden is on the parties seeking the fees to come forth and establish what is reasonable attorney's fees. And usually what is done, I mean, in an uncontested case, like an uncontested mortgage foreclosure, you're going to come in with an affidavit from another lawyer saying, I've looked at the file of so-and-so, right, never happens, and I determined that X number of hours was reasonable for the work entailed, and I looked at this, and this, and I think that a reasonable fee for this would be $2,500.
That's like an outside opinion.
It's called, it's an affidavit from a third-party attorney going for the court. Now, if there's an opposition, the other side can come by and says, no, I'm not taking that affidavit, I think that's foolish. Bring that person in to testify. You know, if you're in trial, you bring in expert testimony, it can get involved. Normally it's not. In an eviction, usually the court will make a determination one way or another because they're not going to award thousands and thousands of dollars on a simple residential eviction where it just isn't appropriate. But so reasonable, again, like unconscionable, it's a floating word, but it is subject to evidence of whether it's an affidavit is sufficient or you have to have live testimony. I had one situation, I was doing mortgage foreclosures back in, I don't know when, I was down in Marathon. I had a case, go in there, and it was one of the few times that I remember being home. I was afraid of being a hometown. I went to court, now down there in the Keys, life is a little more relaxed if anybody spent their time down there, but I'm going to court, I was wearing a suit and tie because no matter what summer rules or Keys or anything, I'm going to look appropriate to be in court. The judge comes strolling in, and this is a one-story, not much bigger than a house, courthouse in the middle of Keys, and there were a few of us standing there in suits, and the judge looks and goes, huh, he says, I see all the Miami lawyers are here. Well, that was a little disheartening. So I went, I had no problem with the case, it was easy, but there was opposition, and I present my attorney's fees affidavit, and the lawyer on the other side objected to it that it was excessive. Probably wasn't. So rather than postpone everything and go and get testimony and go through this, I turned to the opposing counsel and I said, will you agree to? And I offered a lesser amount. She said yes, we agreed, I got my judgment, we were done. So that's how it works in the real world. Okay. The thing that always causes controversy in residential leases is the security deposit.
Yes.
Oh, I hear some knowing noises. So we've all had experience. Many people have had experience with security deposit. So the statute provides that security deposits and advance rent, very often you'll hear people say, I want first, last, and security. Last month's rent is deemed advanced rent under the statute. So the security deposit and the advance rent in a residential, this is where we're going to distinguish between residential and commercial, in a residential lease has to be segregated. And it's by statute. It's got to be put into a separate account for the benefit of the tenant. The landlord cannot commingle, and I'm reading right out of the statute. Landlord shall not commingle the money with the other funds or do anything with it. They got to be kept to the side. Now, I will tell you, smaller landlords don't necessarily follow this. They violate it because they don't really know the rules. But if you look at the Supreme Court lease, whether it's either, they actually attach to the form the entire residential statute, which is burdensome, but this way you can't say, I didn't know what it said, and even if I'm not using the standard form, when I do a residential lease and it's a type lease, I copy certain parts of the security deposit statute that you have to tell them about right in the body of the lease so that everybody sees it. So, it has to be segregated. There are certain circumstances where you have to pay interest. The smaller tenants are exempt from it. The larger tenants do have to put in an interest-bearing account and pay interest. There's notices. If you, again, there's exemptions. So I'm going to stop saying that. I'm just going to tell you that if you only have one or two, or maybe it's less than 5, I think. I will give you the correct answer. I'm not testing this. I think it's if you have less than 5 units, you're exempt from certain of the notice requirements. Okay, I don't want to take too much time hunting for it in the statute, but I believe that's what it says. At least the notice of saying, where's the deposit, what's the account name, what's the bank address, all of those kinds of things. You still are obligated by statute to segregate it, whether people comply with it or not, and you won't wind up in landlord's prison. You just, could be some penalties. So at the end of the lease, this is where all the controversy comes up. At the end of the lease, there's a requirement that the landlord either has to return the money to the tenant within 15 days after the tenant vacates, or the landlord has 30 days to make a claim on the security deposit. To send a letter that says, I'm making a claim on your security deposit because you left a hole in the wall. You stole the light fixture, you took the fan, something you did to damage the property. And there's a form of notice in the statute. It says basically what it should say. And the best way for the landlord to protect itself is to follow the statute. And it says, I'm going to read it to you, and again, you have a copy, but it's good to know what it says. It says, this is a notice of my intention to impose a claim for damage of the amount of blank upon your security deposit due to blank. It is sent to you as required by 8349 Florida statutes. You are hereby notified that you must object in writing to this deduction from your security deposit within 15 days from the time you receive this notice, or I will be authorized to deduct my claim from your security deposit. Your objection must be sent to and it's placed for the landlord's address. So, there's just the time scenario at the end of the lease. You go, if they're not making a claim, they have to give the money back in 15 days. If they are making a claim, they have to make the claim within 30 days. The tenant then has 15 days to object.
So then, one more time on the timeline there.
Okay, if there's no claim at all,
Okay.
give the money back within 15 days. If there is a claim, make the claim within 30 days. If the claim is made within 30 days, because it takes longer to assess the damages. That's it's what statute says, but that's the basic reason. If a claim is made, if the tenant receives that notice, the tenant then has 15 days to object. If they can't reach an agreement, they go to court. I will tell you that these are hard and fast dates. That if the landlord blows that 30 days, and this has happened a lot, if the landlord doesn't send that notice, they have to give the money back. If they send that notice on 35th day, I've actually, once upon a time, actually the first time I ever was sent to court, if they don't do it, you can go after the landlord, you can make them give the money back, and if you have to go to court, you can get attorney's fees from the landlord for failure to comply. So there's a club, the tenant has a club there. There are certain things in the statute that obligate the landlord to maintain the premises. It specifically says there's all kinds of things that you would think about fairly normal, like requirements of building and housing codes, maintaining the roof, the windows, the doors, the floors, the steps, typical things like that. Then there's another statute that expands the requirements for maintenance for something other than a single-family dwelling. So if it's an apartment, whether it's a condo or a rental apartment, the landlord has a lot more obligations to maintain than they do if it's a single-family house. In a single-family house setting, the landlord's obligations may be altered or modified in writing with respect to a single-family home or duplex. Again, I'm reading out of the statute for you. So because, figure it's you're going to have the whole property to the tenant by business contract between landlord and tenant, you can allocate tenant, you're going to maintain things, and you'll see stuff, as a practical matter, you'll see things like tenant has to make all repairs up to $500 per repair. Anything, if it's the roof, if it's the dishwasher, if it's the refrigerator needs to be replaced, then you're going to find that the landlord's going to be obligated for it.
I have a question on
Yes.
security deposit. What happens if the tenant moves out and doesn't satisfy their contract? Does the landlord still have to send a claim?
Yes. Now, part of the claim can be, in addition to damages, that the claim can be for the money that is owed under the lease.
You have to claim that, or is that automatic? I mean, if they...
It's not automatic.
They written the lease...
It's not automatic.
So if they break the lease, walk away, and the landlord doesn't send the notice, by law, they can get their money back?
Yes.
Wow.
However, even
It would be,
if the landlord does not comply and blows the statutory provisions, the landlord can still file suit for the damages.
right.
Or, if the damages are greater than the amount of the security deposit. I mean, there's situations where a tenant can really destroy a place. So, or the security deposit is small. Now, there are times during the course of the lease, and it's not by statute, but you'll see this in most leases, if there's a rent default during the term of the lease, and you don't evict, the landlord does have the right, because it says so in the lease, to apply a portion of the security deposit to the rent default. In that case, they don't have to make, that notice doesn't have to deal with anything except what's left. If it's all used up, it's all used up. Commercial lease will have a provision usually to say that if that occurs, the tenant is obligated to restore it. The landlord has to apply it for any reason. So there's all kinds of obligations, both landlord and tenant, repair obligations. Tenant's got to comply with code, keep the place clean and sanitary, remove the garbage, keep the plumbing fixtures inside the dwelling unit used by the tenant clean and sanitary, operate in a reasonable manner on electrical, plumbing, etc., not destroy, deface, and don't disturb the neighbors. Those are the statutory obligations of the tenant. Access. Landlord has access to its property, and there is an actual statute, because obviously this comes up, that the landlord's access to the dwelling unit may not be denied by the tenant. It's a qualification of that. Because it then says, landlord may enter the dwelling unit upon reasonable notice of the tenant and at a reasonable time for the purpose of repair. Reasonableness depends upon a bunch of things. Or if the tenant is absent. But no, you can't, obviously, you can't just go barging in anytime you want. You gotta let the tenant know you're coming, and it's gotta be reasonable for a purpose. Statute's very, residential, the statute is very specific about hours, it's supposed to be between 7:30 a.m. and 8 p.m., except for emergencies. Or if the tenant, actually, it says, or if the tenant unreasonably withholds consent. And that happens. I mean, no, you can't come in. Well, I have to come in, I have to fix something. Or I have to make sure that you're not running a meth lab in there, or something like that. But you'll know if I'm running a meth lab when the house blows up. And the other thing that's in here, the other thing that's in the statute, and it's probably, what was it put in here? 1993. The landlord may not prohibit a tenant from using a flotation bedding system in a dwelling unit. Water bed. It was an issue. I mean, because, I don't know if well, it's a flood issue, and B, a waterbed weighs about the same as a car. Water's heavy. I think it's 8 pounds per gallon or something like that. They're not popular much anymore. There's a few of them. 70s. There's a very prominent company that you may have seen that sells furniture. What? Yes. You know where I'm going with this?
Yeah, it used to be Waterbed City.
That's how they started, Waterbed City.
Oh, wow.
The gray hair gives you away.
Yeah. I grew up here, so that's the trucks.
But that's the truth. He's right. Waterbed City was the original company, and as the waterbeds became less popular, they started carrying more and more furniture, and then they changed their name. And of course, they grew and grew and grew. But that was City Furniture.
They have waterbeds on Amazon.
They still have waterbeds. They do still sell them. But that was, I'm talking about the old, you had a wood bed frame and a bag of water in the middle.
Yeah.
And that's about it. It was a plastic bag of water. If you were lucky, you had a little thin strip, and this was always amusing. Underneath the bag of water was electricity.
Yeah.
Those are very good friends, as you might know, water and electricity. But that was a heater. And it literally was a piece of a thin plastic sheet with a wire going through it that plugged into the wall.
Can it get frozen up north?
No, it's inside. Theoretically, anything can freeze. I saw a picture in the last week or so of a toilet where the tank froze, the top part, and you know what happens to water when it freezes?
It expands.
It expands. The porcelain exploded. And the photograph was a block of ice sitting there on top of the toilet.
Why did you bring that?
Yeah, that would have been an awesome picture.
That's what Facebook's for. Okay. Termination of a rental agreement. Everybody wants to get out. Then, when I was in law school, maybe my second year of law school, I started getting the questions. And the number one question was,
How do I get out of my lease?
yeah, but the phrase was always, how do I break my lease? And I tried telling clients this over the years, a lease is not made of glass. You can't break it. People want to get out of leases. Now, somebody made a comment about a 2 months notice, but that is something that has worked its way into the standard form of lease. And I'm not sure if it's in the house lease. I know it's in the apartment lease, that there's a provision in there called liquidated damages. So, liquidated damages is an agreed upon number. In a purchase and sale contract, it's the deposit. But in terms of a residential, of any lease, you've signed a contract where you agree to rent the property for a year. You've agreed to pay rent for a year. If you don't live up, if you decide to move out just because you've changed your mind, you still have a contract that says you have to pay rent for a year. So if the landlord wants to take you to court and enforce the contract, the landlord is entitled to collect the rent for the year. In order to avoid all kinds of troubles, the parties who put this form of lease together came up with something to make it a little easier, and there's a provision, and it's a check-the-box provision towards the end of the lease near the signatures, and it says that the parties agree that in the event of an early termination of the lease, the maximum obligation of the tenant will be, and it's usually 2 months, and it's a check-the-box, and you can fill in the dollar amount, and it's an agreement between the landlord and the tenant that if I have to break the lease, I'll pay you 2 months and we're done, you're not going to chase me. And honestly, I used it myself recently because we sold our house, we were renting a place. I found out that because of the tax issues with the portability, I had to buy something within a certain amount of time. We found something. We wanted to get out of the lease. We didn't want to pay for 2 places. So I went to the landlord. I told him what we were going to do. And the landlord was really nice. She said, if I can get somebody in when you move out quickly enough, I'll only charge you 1 month. And so it cost me 1 extra month to get out of the lease early.
I have a question then. So, if you, let's say you're the tenant, and you find a person that's willing to rent a new lease, and it's a qualified person, and the landlord doesn't want to let you out, what happens then?
Oh, I can answer that. That happened to me actually.
Go ahead.
So in
I love this discussion.
So in Pittsburgh,
Or Florida?
no, but
No, go ahead. It's probably very
I don't know
simple.
if it's the same, but actually I have to go find out if it's the same. But we had mice in our apartment, and we contacted the landlord to kind of like, he said he covered the cost to get it out, but they kept coming back, and it was like it became like way too many. It's like it wasn't bearable to live in basically. So
Way too many?
it was a lot of mice. It was like,
Way too many.
Sorry, I think one is way too many.
Yeah. Conditions anyway. So
Unless they're yellow and black with very large ears.
So we had to contact the actual owner of the property, and we had to find somebody. So we couldn't break our lease because we still had, I think, like 4 months left. And so we had to find somebody to take over the rest of our month's apartment, like the amount that we were going to stay. And then they would start a new lease.
Do they know there was
To-
mice?
Huh?
Did they know there were mice?
Well, you can't like disclose
Subleasing
that.
is not allowed.
Wait,
Yeah,
I'm gonna,
that's not.
now allow me to, it's
Yeah,
a
you
great,
can- I know what
great,
you're saying.
you have a great segue for me, thank you, because I'm gonna Floridize that for you.
Sorry.
No, it's wonderful, because I was just gonna get into termination of rental agreement, and in the termination of rental agreement, it starts off with saying what happens if the landlord fails to comply with its obligations under 51, A351, which I believe is the maintenance obligations, that you give them a notice, and you give the notice that it's intention to terminate the lease if the landlord fails to comply. They have 7 days. If they do fail to comply, you can terminate, and you're not obligated for another nickel of rent. One of the things that's funny, not funny, there's nothing funny about it, but under the landlord's obligations are the extermination of rats, mice, roaches, ants, wood-destroying organisms, and bed bugs. So if the landlord doesn't do that, you give a notice, he's got 7 days to correct it. If he doesn't do it, you're out.
That's something that they can't write out of the lease.
Correct.
But that's one of those check boxes, if I remember correctly, so.
No, that's.
Well, that's the apartments.
Oh, apartment.
That's the apartments. You're talking about an apartment or a house?
Yeah, apartment.
Apartments. A house, you could theoretically, in a house, switch the extermination obligation over to the tenant, because it's kind of similar to a life estate situation, where the tenant gets all the rights. You can do it, it's unusual, you don't find it, especially on a shorter term lease. And remember what I said, these forms are 1 year only. So you're not going to shift over the roof repair obligation for a 1 year lease, it's not going to happen. Then there's a concept of untenantability. When something is untenantable, it's a fancy way of saying you can't live in it.
So residential is only 1 year in the state?
No, residential, the form that the brokers are authorized to prepare can only be used for a 1 year lease.
Oh,
Okay?
Now, what you were just talking about, the landlord fails to comply. I've done this before, but when it relates to, and I did it in a condominium,
Okay.
and now you have my wheels turning in terms of, there was a leak coming through the ceiling. I contacted the owner, I read the statute, and got out of the lease because the owner did not reply in a certain time period to fix the leak,
Okay?
which I wanted anyway. So it was,
Well, that's, wanting to get out is not valid.
but it was a legal reason. The roof was leaking,
Right.
right? But in the case where you have a condominium association, would the condominium association be responsible for the roof and not the actual landlord? If you're renting a condo, so you're renting a
Who are you
condo
renting it from?
direct from the owner.
Okay, so do you have any legal relationship with the association?
No, you don't.
Okay, so as far as the landlord is renting you a dwelling unit in an apartment building, under the statute is the landlord's obligation. As between the landlord and the condominium association, you as the tenant don't have to be bothered with that. Okay?
Okay. But the landlord couldn't have used the condominium association as an excuse.
Correct.
Okay.
So then back to my question about terminating. If you find a tenant,
Okay, that's assignment. That's a different situation. And I don't have the document in front of me to see, but I bet dimes to donuts that it says you cannot assign this lease.
well, I'm sure it says you cannot assign, but can the landlord tie your feet essentially to the fire even if you have a qualified tenant that could sign a brand new lease? Would that become like a lawsuit in essence in hand?
That really depends upon, now I'm gonna, and I don't mind getting into a little more technical on something here. That really depends upon what the assignment provision says. And that's a whole thing that I was gonna get into when we get to the commercial leases, but I don't mind touching on it here. So, if the lease says nothing, then a tenant has the right to assign the lease. It doesn't release the tenant,
Right,
but the tenant can transfer the lease.
right.
Okay? Most leases say that the tenant cannot assign the lease without the prior written consent of the landlord. If you stop there, there's case law that says, an old case in Florida, that says that the landlord's consent has to be commercially reasonable. Which means things like, again, we're looking at a commercial lease for the most part. Does the tenant have the financial ability to pay the rent? Does the tenant have the business experience to operate in the premises? All those kinds of things. So that's a reasonableness of the consent. Still doesn't provide for the release of the prior tenant.
Right.
So if the lease gets assigned to a new tenant and the new tenant fails or walks or stops paying, the landlord can go back to the person that signed the original contract. Okay? Now, you can say this lease may not be assigned by the tenant. Period. It's personal. Usually we only do that in a circumstance where there's some relationship between them. It's a sweetheart deal, it's a family, it's a lease to a related business, and you don't want a situation where it winds up in somebody else's hands because there's some disconnect at the family level, whatever the relationship level is. Okay? So untenantability, non-compliance, you can get out. What do you think the number one reason is for terminating a tenant's lease?
Noise?
Not paying the rent.
Ding! Right answer in the back, thank you. Not paying the rent. And remember I said to you There's going to be one thing where I'm going to make you remember the number of days, okay? It's called, because it's a particular form, it's in the statute, it's called a 3-day notice. It's a phrase that's used all the time. The 3-day notice is a notice that says, pay or get out. You have 3 days after delivery of the notice to vacate or make payment. The form of the notice is actually specifically in the residential section laid out there. Let me just make sure. I mean, there's different notices in the statute. Like I said, the residential statute is very carefully laid out here. Where is my...
How is that different from an eviction?
This is eviction I'm talking about, but this is a prerequisite to an eviction. Before you can file an eviction, a residential eviction, actually any eviction, but by statute, before you can file a residential eviction, you must serve this 3-day notice. And without I don't want to spend time hunting for it in here, because I don't need to read you the exact wording. Yes?
So you issue the 3-day notice after your period of redemption or something like that? After?
No. It's nothing to do with that. If the rent is unpaid, now, you could by lease, you can make it longer. But by statute for residential, it's a minimum of 3 days. And it says you have 3 days excluding Saturdays, Sundays, and holidays to pay the rent or get out.
You have to be out in 3 days, or you have
Out.
You got to be out in 3 days.
Okay.
That clock starts ticking from
There you
the
go.
day
Service when you serve the notice.
No,
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 but
no.
when can you serve the notice?
Can you serve the notice? So most
day
cases
after?
they're gonna have a grace period.
Maybe.
All the ones that I've seen residentially, at least,
Yeah.
they tend to have a grace period.
Okay. So when the grace period is over.
There we go.
So you do have to wait until the grace period.
Well, because technically, if you have a grace period,
Uh-huh.
the grace period really extends the due date, is all it's doing. So instead of it being due on the 1st, it says, due on the 1st, but I don't really mean it. Due on the 5th. Then if you don't get it on the 5th, then you send the 3-day notice. The 3-day notice is nasty, because it is a prerequisite. Now, they've liberalized this a little bit, but it used to be very, very strict that if that 3-day notice didn't follow the statute to the letter, the courts could throw you out. And what would happen, there was a lawyer in town, named Chuck Simon, I only know his name because we grew up together, and he represents tenants, and he likes to represent tenants in the defense of evictions. And what would happen is you'd have Joe Landlord who, oh, I do this all the time, I don't need a lawyer. And Joe Landlord would shortcut the notice a little bit. And it's funny because I really would like, oh, here it is, I'm sorry. It goes on and it says, I'm going to read it. You are hereby notified that you are indebted to me in the sum of blank dollars for the rent and use of the premises, blank, now occupied by you, and that I demand payment of the rent or possession of the premises within 3 days, excluding Saturday, Sunday, and legal holidays, from the date of delivery of this notice, to wit, on or before the blank day of blank. And then you have the landlord's name and phone number. Well, I had one genius client who decided that he couldn't really count 3 days. He was afraid of making a mistake. So he just didn't put the rest of it. He stopped. 3 days from the date of delivery of the notice, period. And he delivered the 3-day notice. Well, the 3-day notice was defective. And if the 3-day notice is defective, you don't have any rights to the eviction. So this lawyer who specializes in this stuff goes and files something on behalf of the tenant before the court to get the case dismissed and moves for attorney's fees because the 3-day notice was not strictly construed. It wasn't followed exactly the way the statute has it. And so this guy got a reputation of doing this, and like I said, his name was Simon, and people would say, oh, you got Simonized, which was, for those of you who don't know, it's a car wax. But, okay. So finally, the Landlord-Tenant Committee of the Florida Bar got together and said, this is ridiculous what's going on around the state, that people are getting thrown out and getting attorney's fees assessed against them for a comma missing or one word differing. So they changed it so that it reads substantially the following. They added the language so that you don't have to be exact word for word, but you better be close, and to be safe, use the form. So if any of you are doing property management, don't mess around with this form. It is a prerequisite. It is the key to the courthouse door. You cannot file an eviction without it.
Say that again.
The 3-day notice is the key to the eviction courthouse door. You cannot file an eviction without it.
That is to say,
In residential.
that is to say you have to have that regardless of before
It
you
is a
start.
prerequisite. You must have it. This is important. Write that down. Well, know what that means, right?
Yes, exam.
Right. This is the only thing I said. This is the only thing where I will hold you to the number of days.
3-day notice.
3-day notice. You expect to see this. Okay? Maybe.
And that needs to be posted.
Well, there's different ways to do it.
Oh.
So what happens is it's served upon the tenant. Usually, you're not going to be able to just knock on the door and say, oh, by the way, here. Okay? You can mail it, certified mail.
You can?
Oh, sure. How many times have you gotten a tenant who hasn't paid the rent to sign to the certified mail?
Never.
So you post it. And when you post it, you get an affidavit of posting.
Take a picture of it.
You get a picture. Yeah, that's a good one. Well, now, because it's different today because everybody's got phones and you take a picture of it. Or you have a third party put it up there, or even the landlord really, but it's a little safer if it's a third party who files it. Actually, you have them sign an affidavit. I went to the premises located at, and I taped the 3-day notice to the door.
I had a roommate and they didn't pay and I was going, and I put a 3-day notice on their door and I took a picture of it. Would that be sufficient? Because it's within my house?
That's a very good question. It's a good question because that's a problem for a lot of people. Did you have a sublease with your roommate?
No, it was my house.
Did you have a lease with your roommate?
Yes.
A written lease?
Yes.
Oh, okay, then yeah, that would be fine. Because what was the definition of the premises your roommate was leasing? His room?
His room in the common areas.
Okay, so yeah, that's fine. That would work. That's unusual. That's actually very professional because what happens usually, it's the informal situations that always cause the most problem. And really, the roommate's not the one. It's the boyfriend-girlfriend situation where you move in together and one person has the lease or one person owns the property. And as somebody used to work with, you say, when love flies out the window, you're staring across the breakfast table at the person you don't want to be living with anymore, and it's a problem. Because are they a tenant? Are they what? And there's no, so I mean, you just have to try and treat it like a tenancy and see what you can do.
So what if you go and you post it up on the door and someone takes a picture, but I don't know, say the person's on vacation for a week, so it's been posted for 3 days, but they're in a completely different state the entire duration that's been posted.
Too bad.
No excuse. If you're going on vacation, it's great. Have a nice time. Pay the rent before you go. That's fine.
You should pay the bill.
Pay the rent. You can afford the whole thing. Just pay the rent.
Yeah.
Now, interestingly, there is a provision here. Sometimes, and the statute may even provide for it, I think it does, you get into a dispute between landlord and tenant, and the tenant says, if you don't fix this, I'm not paying the rent. And there's actually a provision in here, I don't usually spend time reading this. There's something in here that says that if the landlord fails to comply with the maintenance obligation after the tenant's given notice, the tenant can withhold rent. Now, it's one of the few times that you're going to see a statutory provision, and again, it's in the residential side, where the tenant can withhold the rent. If the landlord files the eviction anyway, and they get into a dispute, and it's not necessarily a non-payment situation, but it's a withholding of rent, then there's a statute that provides that in order to maintain a defense to an eviction proceeding, other than payment, so tenant doesn't pay the rent because the roof is leaking. The landlord files the eviction. The tenant has stopped paying rent because the roof is leaking. Now they want to go fight about it in court. The statute says that in order to stay in court, the tenant has to pay the rent into the court registry, the rent that's claimed to be due under the complaint, and each month as it becomes due. And the reason for that is it prevents a situation from the tenant playing games and putting up defenses just to not pay the rent.
Is there a fee, a court fee or something for filing and maintaining that?
I don't believe so. I don't know, it's been a long time, but, well, there's a quirk on the commercial side, it doesn't usually come up on the residential side, and the quirk is evictions are filed in county court as opposed to circuit court. County court has a $15,000 jurisdictional limit. So if you've got a commercial setting where the rent is $8,000 a month, as soon as you put 2 months into the registry, you're over the jurisdiction of the county court, which means that technically the county court judge no longer has authority to direct that the money be dispersed. So the case has to get transferred to circuit court, which doesn't sound like a big deal here, but as a practical matter, certain courts are much busier, they're much more formal, and the county courts are set up to deal with evictions. But big bucks has to be in front of the big boy court, that's how it works. Okay, I think I have exhausted the residential issues. Dwelling, water beds, termination, ability, non-compliance, 3 days. Oh, one other little thing, and that's in a residential mortgage foreclosure. There's a little bit of protection. If a mortgage is foreclosed, the tenant under a valid lease has 30 days to leave. The exceptions are if the tenant is related, it could be the mortgagor or a member of his family, or you have a non-arm's length lease, like a lease with the brother-in-law or somebody they have a relationship with, or if the lease is so far below market rent that it's just not a legitimate lease. In those circumstances, you can foreclose and get them out right away. Right. So, for example, you can't have a lease to your sister and be foreclosed and expect, her lease to supersede the bank. Okay.
You're saying like, okay, so if I own a property and I stop paying the mortgage and I have someone who's rented from me, pay me $1 a month to stay there. Out. That's right. Right. But otherwise, if it's like legit.
If it's a normal lease, they have 30 days.
But aren't they protected? I remember if the lease was like for a year, that you were protected from getting kicked out. I mean, I knew that came up during the housing.
It expired.
It expired,
yeah.
Oh, it doesn't exist.
And so Florida, we passed something, it wasn't quite as liberal, but because it went back and forth as to whether to keep that protection in place or not, and they let it go, and they just went to a lighter, a less tenant-oriented situation there. And it's got, the whole circumstance with foreclosures and tenants got so badly abused for a very long time that it was the mortgagor, the owner of the property, was taking huge advantage. Especially, it would take 4 years to foreclose. Yeah. Sometimes, and they would just keep collecting rent. So, okay, so I think I've beaten the residential tenancies to death.
So they could not pay their mortgage for 4 years.
But if we miss 1 month,
but they can make me pay rent or whoever.
And then if I miss 1 month, I'm out.
The tenant?
Yeah.
Well, under an eviction, yes.
No. They cannot not pay mortgage for years.
Well, not legally.
And then,
not legally. So here's what happened with the
foreclosure process, for example.
The foreclosure process just took forever.
Yes, but by the meantime, let's say I'm a tenant and I'm not aware of that. Let's say, for example, I have something coming up, and I can't pay my rent for that period of time, or I'm late. So after the 3 days, notice.
Well, if you can't come up with the money, yes, you're going to get evicted.
Although the person is not
completely separate.
Okay.
Completely separate. Is it fair? Well, yeah, it's 2 separate contracts. Just because he's bad doesn't mean you're allowed to be bad. That's kind of the way to look at it.
So the person cannot give me a chance by the chance that they have been given.
Now you're getting out of the law.
Yeah, I know.
Now you're being moral about it.
I know.
There's no place for morality.
I know.
Even if the property's under foreclosure?
That's where we fail.
What?
If the property goes in foreclosure?
Yep. And?
You're still paying the owner rent?
Yep.
You are? Okay. He's not the owner. Is he still the owner?
He's still the owner until that gavel falls at the courthouse steps. Did I talk about the courthouse steps of the sales?
Yeah, you did.
Yeah. There's
no steps here.
Okay. It's online. It's all online.
Okay,
Okay.
thanks.
How common is adverse possession? I know a few years back there was a big story about, you know, all these people were getting away with murder because they were occupying these million-dollar homes and no one was like, and not paying any rent and no one was kicking them out. And there was all these
That's gotta go, okay, so adverse possession's gotta go on open, notorious, and hostile are the magic words. And I'll try and put that into, you know, I gotta come up with stuff for another couple of weeks, so. You think it's easy? So adverse possession is a 7-year statute. You have to possess that property, possibly openly, you can't hide, openly possess that property to the exclusion of the owner, and there's other terms for 7 years before you can have title to it.
So you just gotta be under the radar and live in the home for 7 years?
Not really under the radar, because...
I mean, under the radar for them not to notice that you're here.
So, where it usually comes into play wouldn't be, I mean, I don't know where you see a story about $1 million home, unless you got an offshore owner that never comes here. I mean, theoretically that's possible. The normal times that you see this, is when the fence is too far over the line, or something like that, and you are using part of your neighbor's property. More likely you're going to see this in the big land areas where that's an extra 5 acres of the ranch land and the fence is over too far. And there's also rules, maybe you're including that on your real estate tax bill, and you're paying taxes on that extra 5 acres and things like that. And it's open because you're doing it. You put a fence there, so it's hostile. You're keeping your neighbor out. You're not hiding anything that's notorious. And if you can get away with it for 7 years, you can change the border. It doesn't happen much, but it happens.
We had one of our large track holders, we had a gypsy camp in there that was established at 30 years. And yeah, they got the parcel, not the whole parcel, but their section.
Who's going to fight with the gypsies? So, okay. Please forgive the gypsy discrimination. Are they protected? Anybody take con law?
No.
Are they a protected class?
No.
You never know. Well, what are they? Are they a nationality? Are they a race? Are they an ethnicity?
Are they a religion?
Well, any of those. Any of those are considered.
There's protections in Europe, but not here.
Well, but if they meet any of those type of criteria, they could be deemed to be a protected class. Now, maybe they're not recognized as a protected class here, but you never know. And it also depends. We're not really talking about a discrimination situation, and this is way past the scope because this is common law. The only time I ever fell asleep reading a textbook, because those old guys in the 1800s when they would write these opinions, they were boring. But I mean, that's how the law was created. It was all the precedent, and they went, because when the United States Supreme Court does something and changes things, their analysis goes through all the historical analysis and all the economic and social reasons why, and so their opinions are very, very long and very detailed because they have to be. Okay, so let me talk a little about what happens in a commercial lease, in a non-residential lease, when things go bad. So again, there's same thing with the tenancy at will and the length of the tenancy and the length when the rent is paid, or it's a month to month, week to week, quarter to quarter, unusual, year to year, how many months notice you have to give, days notice. If the lease ends, either because it just came to the end, or because you've evicted them, or you've terminated them by notice, or something like that, and the tenant doesn't leave, that happens all the time. This now becomes what's called a tenancy at sufferance, as opposed to tenancy at will. Tenancy at will is by agreement, and it can be terminated with the notice. A tenancy at sufferance is a situation where they're not supposed to be there, it's contrary to the agreement, they've violated the contract, they have not done what they're supposed to do, they didn't get out. keeping in mind that any of these terms can be modified in a written lease, the statute provides, where the lease is silent, that where the tenant refuses to give up possession at the end of the lease, the landlord may recover double rent. There is that. And a little bit differently, yes. Here, oh, sorry, I thought a question,
So it's double rent for a single period, like
For the time that they are holding over.
holding over, okay.
Holding over is what it's called, it's a holdover, if I can say that, I'm sorry. When you stay past when you're allowed to stay, the lease ends and you don't go out, you're holding over, you're staying in possession. The notice for failure to repair, now, see, in the commercial statute, everything is when the lease is silent. But there's notices, because all the notice times and provisions are usually by contract in a commercial setting. But if the landlord's not doing something to maintain or it becomes untenable, the tenant gives a 20-day notice, and if the landlord doesn't do it, the tenant can leave.
After notice to repair?
Yes. Also, talk about serving these notices and the summons and things, and that you have to make 2 attempts under the commercial side of the statute to serve a notice. Actually, to serve an eviction. So this is in an action to remove the tenant. So after 2 attempts to obtain service, to evict a commercial tenant, if you cannot find them in the county where the action is pending, and the defendant has no usual place of abode in the county, the sheriff can serve the summons by attaching it to some part of the premises involved in the proceeding. That means posting. And just interesting little thing, the 2 attempts to serve have to be at least 6 hours apart. So you can't drive around the block and go back when they're not home. Yes?
I have a question. So they're in default. They're currently in default. They haven't paid their rent. You still have to do 2 attempts just per the.
Those are attempts to serve. Okay. Let me
serve
rewind.
after.
Let me rewind. This is past the 3-day notice now. Now
Okay.
you've done your notice.
We have judgment already?
No.
Okay, no.
Now you go to court to evict them.
Okay.
Okay? When you start a court proceeding, the first thing you do in the court proceeding is file a complaint with the court. The second thing you do in the court proceeding is you serve a summons. The summons is delivered by the sheriff, and I think we talked about that at the time of foreclosures.
We did.
So the summons is either delivered by the sheriff in most cases, or in some cases it can be a private process server. And the summons is delivered to the defendant, and that starts the clock ticking, and they have 20 days to file an answer.
So that summons, they have 2 times?
2 times to try and hand you personally the summons.
Okay.
Or in an eviction, they can post it. Now, if you remember what I said when we talked about foreclosures, in order to get a money judgment from somebody, you have to touch them. That means you have to personally serve them. And in rem, if all you're dealing with property, whether it's taking away property in a foreclosure, quiet title action, an eviction, and you don't care about getting anything from the human, then you can post, publish, do things like that. Eviction requires posting.
So then that's the same for residential and commercial?
I'm on commercial here, right?
Here, I'm reading from the commercial statute, but you still have to attempt to serve. The posting I was talking about before on residential was for the 3-day notice. Now we're in court.
Yeah, so then in commercial, do you have to have a 3-day notice as well?
Actually, interesting question is that there's no statutory requirement of a 3-day notice in commercial. However, no judge is going to let you proceed with an eviction, even on a commercial eviction, if you don't have some notice like that. Now, very often commercial, there will be a provision for a longer notice and say, okay, if I'm in default under the terms of my lease, then we can have a 5-day, 15-day, 20-day, and that's always negotiable.
What's it take to get your money out of a commercial entity where the entity goes bankrupt and Is there any, do you have any?
That's a compound question.
Well, I just, well, you know, it
Okay,
could
so
happen.
here's the
Somebody rents
story.
your place and,
I lease you a piece of property to your LLC that's gonna do business there. You don't pay the rent.
yeah.
You move out. You either move out in the night, I evict you, whatever. But we still have this contract between us for a year's rent. What's in your LLC?
I don't know. What's,
You leased, your LLC leased, does it own anything?
yeah, that's right. May own.
Does it own your equipment? Does it own anything
Yeah,
major?
I like furniture in there. It may,
Furniture,
it
how
may
much
have,
is furniture worth? Is it worth a month's rent?
Probably not.
Okay, so if I try and come after the LLC,
Yeah, it's a lose.
I'm gonna wind up with a beautiful judgment. And if I go to Marshall's with a coupon, I can get it framed. I can hang it on the wall. We're gonna talk about it later, a little bit later, because we're gonna get out of the statutory and these things. We're gonna get into the leases themselves shortly. I'm gonna tell you how to fix that.
I was gonna say, couldn't he just do, build in a personal guarantee into the lease, and then now the person is personally liable for the
So
lease?
you do not need to be here between 3:10 and 3:15. That's what we'll cover personal guarantees.
Okay.
That's a joke. I have no idea what I'm gonna get to in my
That's
hour.
fine.
Okay, but yeah, that's the answer.
Okay.
There's different types of personal guarantees. So let
Isn't
me
that
just.
the whole reason you have an LLC, so you don't have to put your personal?
Okay, that's great, and usually it's to protect you against judgments and things like that, because if you're operating your widget business, and your widget breaks, and because your widget broke, I fell off my Widgetron and hurt myself, okay? Now I'm gonna come sue the LLC for manufacturing a faulty widget. I'm not gonna take your other assets away from you because it's in the LLC. But in a commercial business, you can do that. In a professional business, you can't. Doctors, lawyers, accountants, architects, we can't shield against professional liability in an entity, even though you'll see PAs and LLPs and all kinds of things. Those are for tax and business reasons. You cannot shield against personal obligations, professional responsibility.
That's why they have insurance.
Correct. That's exactly right. Then you shouldn't make mistakes. Be careful and think twice before doing stupid things. So, most of the time when you find liability issues, it's because somebody took a shortcut.
We see the Ventures LLC backed up by the Holdings LLC.
You're making names up. It doesn't help.
No, I mean,
It's not going to do any good.
you see what I'm,
You just have a subsidiary. Don't confuse. We'll get to how you make where the money is later.
okay.
I promise. 3:15, 3:10.
I'm supposed to be asleep at that time.
I know when you. Trust me, I know when you guys are asleep. I see it. It's about 3:45. Double rent. Oh, this is something important. So, another way that the landlord can be protected. So even with your LLC out there, now, is that the statute, and it's usually in the leases as well, give the landlord a lien on the tenant's property. This is commercial, not residential. Which means that if you have a lot of property, let's say you're a car dealer. Well, it's a bad example because they finance everything. But let's say you have a lot of inventory, or you have a lot of equipment, and you own it. Or you have a lot of it's a warehouse with a lot of heavy racking equipment and forklifts and things like that. The landlord has a lien to secure the payment of rent on all of that stuff, so that there are statutory procedures to enforce that lien to go after the rent money. They can. Primarily, this is for the protection of rent. I mean, if there's other issues, I mean, you're not going to go after somebody unless there's money involved. You know, and there could be money damages, but it's usually the rent.
So, but wouldn't the landlord have to own the equipment of the tenant?
No, the tenant owns the equipment.
But
The
they
tenant
have
owns
to
the.
put a lien on.
You put a lien on it, then you have to foreclose it. So the proceeding is called distress for rent. But I'm not going to get into that's a litigation concept, but it's basically a concept where the landlord can go to court and execute on his lien and take the tenant's property in satisfaction of the debt.
So is that lien statutorily provided, or
Both.
is that recorded?
No, well, it is provided by statute, the question is the priority.
Okay.
And that's beyond our scope, that's a UCC concept. And that's just, they'll make everybody crazy. Oh, another, and I'm sorry to war story, but it's not really a war story, it's something that back in, I don't want to tell you how long ago because I don't really want to date myself, but it was a long time ago. I was a young lawyer and I got appointed to the Florida Bar's Landlord Tenant Committee because I've been enjoying this nonsense for a long time. And I came across the provision in the residential side of the statute that said, in an action for eviction, if the tenant has a defense other than payment, that the tenant has to pay the money into the court registry in order to maintain the defense. Remember, I talked about that a little while ago, and it was a protection against nonsensical defenses to be able to stay in the place without paying rent. And I looked at this, and I said to the more seasoned members of the committee, I said, this is a really good concept. Why don't we have this in the commercial side of the statute, where it's much more likely that the tenants are going to play games to try and stay in? Because a residential tenant is not very sophisticated, but a commercial tenant really has an opportunity to play games like this. And they said, gee, that's a pretty good idea. Why don't you write the statute? And so I took the residential statute, which said, I believe the words were, in an action for possession of a dwelling unit, and I took my pen, and I crossed out dwelling unit, and I wrote in real property, and I said, here. And what happened was, that made it into committee. And when it made it into committee, the committee included all kinds of practitioners, a bunch of us, and it also included, at the time, a county court judge who dealt with this on a regular basis. And what happens is, the result is a statute that you have in your materials, which is 83-232. Oh, it's got a date at the bottom. Let me get myself away. 83-232, which is the commercial version of the same thing that we wrote in committee back then. And the whole expansion of it that came out of that committee was that the tenant had the right to a hearing to determine how much money had to be put into the court registry. And that's pretty fast, because what happens is it's done quickly because the landlord wants this to happen fast, so the judge, there's something about expediting on the calendar and things like that. So, because the landlord might say, I want you to put the rent is $10,000 a month that has to be put in. The tenant goes, no, it's only $5,000 a month. You're lying, you're mistaken. And so, you go in front of the judge, and the judge listens to the testimony, looks at the documents, and says, no, it's $5,000 a month. Tenant, you're late 3 months, you have 48 hours to put $15,000 to the court registry. And at that point, the tenant can put the money to the court registry, and a case goes on down the road on, you're blocking my driveway arguments, or he doesn't put it in, and the court will immediately enter a judgment. He'll default the tenant, enter a judgment, and the eviction is done. Because that separates the nonsense defenses from the real defenses. That's important. It's important, not important for you to worry about it. It's a really important concept in the law because it prevents messes. It prevents things. And honestly, I'd like to see it in the foreclosure arena as well, because there are so many nonsensical defenses in the foreclosures that are just a pain, and it can delay foreclosure for years. Okay. With that, it's almost 2:30. Let's take a little break, 10 minutes, 15 minutes or so. And then we're going to dive into the leases and the types of leases, and away from the statute and into the real meat of the topic.
I guess it's like completely there. I think I thought
By the time we get there,
it's like
do that. I think I just fixed it.
Were you able to find a replacement?
Yeah.
Yeah? I'm sorry. It's just, I'm not grateful.
It wasn't for you. We wanted you.
When I emailed, listen, when I emailed you, I literally had three appraisals come in that were all bad. And I'm like, oh, I can't do both, and this is gonna be.
You got an option. He's gonna take the work. He's definitely gonna be taking the bulk of that right there.
There's some stuff in shady that was interesting.
I couldn't even get it to like you know the problem he said earlier, people are hiring, and then he said click the fix, that didn't work.
I know.
So then I did some crazy
I'm gonna email that they,
but now I wish now I'm like, because look, I got it connected now.
No, I learned the same way. You don't want to have these.
you have to import that all that stuff in it.
What?
Way too
You never showed us that.
Yes, you did.
This is the installation. This is the second video.
He just talked.
Yeah, but he would show you where to go.
He does show you. He goes through it. And after that, he goes through it.
Tells you where to record it.
Yes, yes. Because I'm past that already.
I'm gonna post both eventually.
Sure, I think about import. I think I got everything else.
You gotta do all the stickers.
What? To what?
This stuff you're gonna have to do later on.
I'm saying that the first step is to get the.
And I forgot all about that project.
Like it says first steps on AD.
Yeah.
She's like,
You already have.
I need to do an alumni board.
You're not. That's like the end. This is the end result.
No, what you really need, he's just going over, he's just showing you exactly. He doesn't have.
Yeah, and a whole update on how you want to do
It's gonna be a sheet on,
sitting here in my mouth.
that he actually has you print out, and then you enter all that information into the thing, and create your file. That's just his,
What is he?
he's just showing you how to set case one. But
So you're saying this is where you want to all you have is portfolio one.
I didn't have portfolio one is yours. And then he goes, yeah, and then he shows you how to push it.
To create the portfolio.
Yeah.
That's part of case one.
Yeah, case one is, see, like, this is what I have. And you'll see.
Oh, you need these Excel files.
Yes, you start.
Oh, yeah, they're gonna start creating portfolio.
Yeah.
So why would he say when he said first steps he's gonna show you all that stuff?
Don't even listen to it.
Dude, I still see it.
Don't even listen to it.
You should have had to do to connect.
I had to.
I went to taskbar and I deleted something and then I just copied it. Because I made a copy of it, so and I did this.
See, you need to have
All
in
that.
class one, training case one. Training case one is really gonna be your secondary file. This is where he teaches you how to do everything. In class one, yes.
That date is touching. I've got a week.
See, I finally
You
connected.
just jumping all over the
Nah,
place.
because I didn't even connect. I literally
Seminars?
just found
In fact, this week on the 13th, I'm doing a webinar on cannabis leases.
I just had that problem. And to get like one thing.
So, yeah, I have a-
All he says.
I could-
it's gonna work and it doesn't.
It doesn't work.
Kept-
That's what he told me, it doesn't work.
So when it was saying how like, I had two of the same things and then I couldn't delete one of them because there was a server running, so.
I mean, you may be talking to Alicia about doing a land use unit on it,
Yeah.
which is something else.
When it.
I hope you haven't interrupted.
I might have to be saying, I think I done something.
Maybe that's what I did.
Yeah, is that the new?
I was getting this much.
I didn't change that logo.
She was having a problem too. She just called me, so I was just
It's
like,
like,
oh, Monday, but.
really, like really old.
And they said, no, logo has a little pin.
Happens on there.
Oh, yeah, that's right.
Gmail.
What the fuck?
Police launch nationwide manhunt for armed and dangerous corrupt lawyer who stabbed his mother to death. What? Let's see if this is Florida. No.
And then is he gonna file a wrongful death lawsuit?
Huh?
Is he then gonna file a wrongful death lawsuit?
I don't know, but he's from Atlanta.
That's like the guy that insured the box, well, I don't think it's a joke, it could be a joke, but the lawyer that insured the box of cigars and then smoked them and filed a fire claim? I can only hope that that's a joke.
I think I'm busy. This now. I gotta yell.
No, I didn't delete the email because I was like, if I need it again, I'm gonna, I need it.
So there's nothing stopping you from being entirely funded by a small
I don't know what the schedule was for the investment class.
Is there nothing
There's a case study. That's the next speaker's case study in 2 weeks.
First or second of March?
Second one.
These guys are not.
Mr. Smith, is it true that you wrote this article, this opinion piece for the Washington Post? It's to women who are unseemly that doesn't mean they were illegal. Okay, great. So, green light for hush money. I can do all sorts of terrible things. It's totally legal right now for me to pay people off. And that's considered speech. That money is considered speech. So I use my special interest dark money funding campaign to pay off folks that I need to pay off to collect. So now I'm elected, I'm in. I've got the power to draft the laws and govern United States.
That doesn't,
Is there
that's
any
you
part
never
of
said
it that
something.
I have, perhaps
And then you'll see it's two different.
I don't think that would work.
what legislation
Whatever.
allows
You just said
us
it.
to run any limits on the laws that
I got green, so I'm good. I got no hair.
especially if I'm based
Look at the
on
free comeback.
the special interest funds that I accepted.
Are you selling them?
One of them I was,
Go to-
but then the other two, I'm doing the sellers.
The only problem I was having was,
Of course.
and there was,
She just
See, this one, see, this is what they tell us, so it automatically goes to the window or and not to the SQL
but he
server.
doesn't give
Look,
you.
this is nice stuff, yeah.
And it says, use existing
I had
SQL
to do that a lot.
instance, and it says,
And then
use
what
that.
oh, you put your stuff in?
And then hit the select button, not
Yeah,
the
but
tab.
what, now you need a user ID and password. That's why I didn't, maybe you use your,
I use my user ID and password.
so you know what I did?
You know, you don't have pools.
Yes, I know, they have to have proper justification, some of the correct years.
I don't wanna reply.
It makes me mad.
Yes, okay, great. Is it possible that any elements of this story apply to our current government and our current public servants right now?
You guys use somebody else?
Yes. Yes.
Is anybody else?
So we have a system that is fundamentally broken.
That's weird, we wouldn't tell
We
you,
have
right?
these
User ID and
existing in this
password.
file,
You may have.
which means that
I know I contacted
Those guys
I
are,
was like,
here, in
they
this
come
going on
page,
here?
the questions that are being asked of you all right now.
That's not what he says to fix it.
Would you say that that's correct?
You should have seen
Just
that.
like
When
I had a
when he
situation where
said, oh, do all
the
this
home
stuff,
where I
All
had
right,
to
so,
sell, the guy is using his
one
mom,
last
it's
thing,
across the
Mr.
street,
Shaw.
7
and
months
he
old.
says all this stuff, and I do it, and it doesn't
it's
work.
$40,000
Congressional
below
oversight that
appraisal.
So then I'm
they are
like,
based on meetings and
They're sending $40,000 below appraisal, and he's not
compared to the
factoring it in.
executive branch,
It doesn't
compared to
cancel
the
it.
President of the United States.
I was,
Would you say that Congress has the same sort of standard
It's an
towards their
it's not working out now.
in that
and
regulation?
if it was
Is
noted
it
in
in
On
there,
the president,
Did not.
or would you say it's about even,
Didn't.
or more so
and his
federal?
justification was,
he saw
oh, and his justification was that he used it to only come in the name of within the year. Fair enough, but don't use it and not point out that it was like sold $40,000.
And it's already.
And that's all, as soon as I did that,
For me to be a pretty bad guy.
it was like nothing.
So
So
it's
you
even
get your
easier
you get
for
your
the
county
president
here.
of the United States.
I
It
do
would
it
automatically
on
have.
Open
But I'll make that
Oh,
this
I
selected,
got
right?
it.
Yeah.
Did it.
So when you have this one, you go get
Very
Aaron,
bad.
blah, blah,
And then
blah, can't
Yeah,
stop.
they can't do
I
it.
went out
You know how
and
there's
bought completely.
gated
And
communities
then I
that
went
one's gonna be a
into
little bit
where
more
it is,
valuable,
which
there's
is,
based on
and I made my,
the
I made a
size,
copy of
based
it,
on how they're
which
maintained.
it won't let you,
File?
which it won't let
He's
you do
comparing it
unless you go into task
to
manager
a
and
gated
stop the
community
server
that's
from
not
running.
minor,
Then you can delete it and copy.
not
So I
as
made a copy of it,
nice,
yeah,
not
I
as
copied it.
small.
And then when I got here again, I
And then
selected
like
the
you're
copy
not,
version.
he's getting a
Yeah, let me
$3,000
show.
for as a site.
Wow.
For that,
And then
it's the same thing, but.
one of the houses that I gave him
heavily look.
is a comp that has a 3-car garage,
Give me,
right?
it's annoying you because.
But has a
I'm not gonna
4-bedroom.
start doing it.
Gives $20,000 for the extra garage, only gives $3,000 for the bedroom. What?
this is square foot.
Trying to get my resume.
No, it was like, I think it was like a $200 difference.
Got more studying.
Yep.
There's
So
a
I
whole
was
conspiracy
actually
theory,
the car.
millions of people they follow it apparently.
No,
Is he one of those that's just really tired? It's like all the reasons I say that later.
the shit I'm doing.
I don't know why you do the job if you hate your life.
I have no, we'll see a lot of them, at least back home. I don't know how it works here, but back home.
Finance class, I never heard of it. Real estate school.
You know, back when I got into
The
the
masters.
Yeah.
You're doing what now? It's like the basics.
Yeah, it's
They do
very
herb,
basic,
yeah.
yeah, you learn everything. But it's very basic, computer
It's
to
just,
like
there's just so much
NPV,
tough stuff on there.
There's no, they
internal
don't make you like
material.
a calculator.
Literally, that's all the stuff
It's
that's
all
on
basic
there.
shit.
It's not like believe.
When those guys got
It's degree.
four places, always they were at arm's length.
No, here, they're in a pool, and they start.
I'm saying all this shit like.
See, they just changed that to
They don't
back
require
Yeah.
That just changed.
And
She used to think
you
you
have
take
to
this
have
as
a
well.
bachelor's
Dear
degree.
God.
You have to
Did you
take
take
hours
your
training or something.
Was there a lot of math questions?
So
It's not like, it's not like,
uneducated.
you don't need to have.
I'm like, again, that, those two that I just explained 18 years ago, right.
Like, they're not gonna make it in present value and stuff like that.
Oh,
It's just gonna be like
hell no.
herb and then also
Right,
like
I agree.
something.
Present value?
I don't
That's what I
think,
meant.
again, I would have been fine with him using it.
Yeah.
Give it the proper value for the fact that
One of the
$40,000. It's a tricky stress. They need to get paid.
You didn't take this flag.
There was a lot of, like double negatives, like, so if you have a 7 and 9, they cancel each other out.
I feel guilty about getting it, not really.
So you didn't do your job.
I finished the portion right now.
So fine, use it.
I'm
But
thinking that I'm not sure.
because the moment you mark that, like I went to this weighted average. If you add the 40 grand, I pay my property.
But not so 18 years ago.
So I made the argument. Oh, it's very repetitive. The buyer's agent, the buyer's agent was working, and she's like.
You do?
That's what
Yeah,
covers
so.
But the nurse.
I'm like, I don't know.
Oh.
Somehow show them.
Right, and you gotta
Yeah.
pass that.
So you don't
Mind you, but it's
Oh, really?
worse than that.
Yeah.
No more?
Signed off, but I mean, I'm not an attorney.
Yeah, I said, I don't know.
So it's
Because
wow,
we
in the gray area.
And I heard
They
that
signed
can
off that
test,
buyer
there's more
agent.
math on the test back when I
But
took it.
they're
And
financing.
there is
So I told them, I said,
currently,
And when I am alone,
They can't get
it's not
like actual.
and they're like, we're invited. I'm like,
And I would, and I would be
You're invited. I'm gonna pass
back
on
in the
this.
day, I was a real estate.
Do my thing, wash my hands. I was gonna hear once or another.
Agent.
You're fighting for
We
my
did deals done.
Yeah, that's true. Normally.
And then after the whole flip-flop events in 2008. And I went back to school, they wanted my grandparents to go through certain qualifications in order to maintain your broker's license, so I just got my broker license lapsed. Yeah, only licenses I
Okay, my mom, on my mom's side,
my real estate
in the
broker
past
license, my nursing license, which is
she was sick.
nursing. They have off-year renewals, which is really cool. So last year I renewed,
My grandma buried.
real estate broker, this year I renewed nursing. And I do education too, all of them, but it's like whatever. So it's off, but back when I did it, there was a lot of that. I remember.
My brother was born this year.
So I have
There was so many times, there was like that.
Probably my brother had met them.
Do they do the 640, 32? Yeah.
Anybody here an expert on Banner?
And he.
Banner?
Okay, I'll bring
And he got.
Banner?
Not an expert.
I'm not getting to my usual place. It can be where I can get it right in the house.
Get it over it.
So I can do the documents. No, it's a chemical.
What pushes
This in Tri-California is worse. It's simple. They're like supposed to have an equal stringent.
At least in my experience, when I was entering stuff for financial aid.
Post 9/11
Let's see if it's cannabis.
They're all.
Where did you do Gold Coast?
Hey, can you just? I would see him saying,
You wanted the gallery. But we didn't need to know that. But I'm not saying that. Not like stuff that's like but we have serious fraud. Bar it's probably a paid. I did not go.
Wow.
I don't like it when I see people in regular real estate license or real estate.
not that you get my cousin,
You really do think you're capable of doing it. Just because you prompted that from the class. Because instantly it's like,
It depends on the experience level of the person.
I think because you're just bigger
No, because you have it on campus.
he put me into me.
It's just, but I'm not sure they can do that.
I do commercial properties, and then I had an owner that gave me my bill, and I said no. I said, nope, I'm not an attorney, I don't wanna touch that. You need to take that back. Okay, good.
What now?
Unless you want to wind up in unauthorized practice of law for prison.
Right. No, I want to go to
It's a terrible place. Second Arkansas.
if it's something standard, then an attorney
I hate that word, standard. I hate that word. Because I look at this many people say standard.
This is like me.
I'm missing a few. Where are they?
I see it a lot, and I continue it like,
The way you
I have to pay.
I know what I'm
Go on
doing.
I don't
You're all so up to
So I want to do
Alright, hello. So I'm going to quickly cover things that people haven't come back yet. We're going to delve into the wonderful world of commercial leasing. And I can't promise you that I'm going to get through everything I want to get through before you all zone out like you tend to do around the 4 o'clock hour. And I decided that it doesn't make any sense to keep you chained to your desks when I hear snoring going on. So I'm not, it just, honestly, I'm cognizant of the fact that you've been here since 8 o'clock this morning, some of you, and the questions just stop around 3:45. And I know, but I understand, it's okay. Material is not always fascinating, but it's been a long day. So I'm going to try and be a little more lenient with that, and I'm only going to test on the things that, oh, you know, you're welcome to leave when I say so, but I'm going to test on things that happen afterward. No.
Thanks.
I had something happen to me when I was in college where it was one of those, it was one course where I guess we met for like 2 hours, and then there was a break, and then there was another 30 minutes. And just every once in a while, just didn't want to stay for an extra 30 minutes. And that SOP covered new material that was on the exam. Yeah. And it may have been the same course where he graded on it was statistics.
Oh, wow. Oh, that's a horrible
I have
course,
suffered.
period.
I have suffered as you have suffered, don't think? And, you know, transportation problems and other good things like that. But this particular guy, he graded on a strict statistical bell curve.
Oh, yeah.
And an 88 was a C. Yeah, that was just, yeah.
Yeah, because
Exactly.
you got 10% fine.
It's wrong. It's just absolutely. So, I didn't know any better. We didn't petition back then. And I'd already used up my pass-fail options or whatever it was. It was too late, so it kept me. It kept me from Magna, which whatever. About the bell curve?
Yeah.
Who thought about that? No. It was,
I asked all those questions are before withdrawal period, just so I can get a free.
that's good. No, you're good. Listen, students today are both more educated as to those kinds of things and braver. This is back in the dark ages.
They'd whip you with a ruler or something.
No, not that dark. That's parochial
I used
school.
to get blue.
And that wasn't me. I wasn't doing anything like that. No, I don't.
I used to get open growing up.
That's exactly right. The ruler on the stuff. Yes, it's parochial school. Okay. So we're going to commercial leases. Leases. I'm going to talk about different types of leases, but I'm going to talk about types of leases in 2 different ways. First, I'm going to talk about, and we're not going to discuss the document yet, although it's fascinating, especially what you're able to see. Types of leases. First, I'm going to talk about leases by improvements. There are different kinds of leases for different kinds of improvements. Simple, easy. Everybody thinks about an office lease. Office lease is typically a box in a building. Like if this were an office building as opposed to a school, you'd be leasing this room. There's retail leases. You guys go into stores all the time. A retail lease could be for a storefront in a shopping center. It could be for a freestanding building. There's all kinds of retail leases. There's industrial leases. Industrial leases are warehouses, car repair places, manufacturing facilities. All that's industrial. Shopping center leases. Now, shopping center lease is also a retail lease, but it's a slightly different kind of an animal because you're sharing, the tenants are sharing not only a building, they may be sharing multiple buildings, they may be sharing multiple buildings with mixed uses, they may be sharing multiple buildings with mixed uses with big department stores that are not tenants, and there may be out parcels with different rights, and there's parking areas and driveways, so it's like almost like a little city. So they're very much more complicated. On the far other side of the spectrum is a single tenant lease. A single tenant lease is real easy. A lease to one tenant. It's usually a freestanding building where the landlord has a building and the building has room for one tenant and it's not shared. There's a ground lease. A ground lease you'll see typically it's literally a lease of the ground, and the tenant is going to build, well, either the landlord or the tenant is going to build an improvement, but the building, anything in and around and on the building belongs to the tenant, and all you're paying for is the land. Very, very often you'll find that for fast food and banks and things like that, where they will literally lease a pad with parking around it, and there'll be a pad in the middle of the parking lot, and that's what they're leasing, and that's what they're paying rent for. Those are, and there's other kinds of specialty leases maybe that I'm not thinking of, but those are your basic different types of leases by the type of improvement. The other way to look at and classify leases are by the business deal. These are terms you might be more familiar with. There's a gross lease. A gross lease is a lease where the tenant is obligated to pay base rent, just one number. That one number includes everything. Not utilities, well, maybe sometimes utilities, but usually not. It's usually just, all they pay is rent, and they get the use of the space. Most of the time, with very few exceptions, they have to contract and pay for their own utilities. A modified gross lease is a situation where the tenant pays a base rent, and the landlord has a provision in there that says, as if my taxes increase past 2019's base, the tenant pays only the excess. And the reason for that is, going back to your finance stuff, the landlord is reaching an agreement to collect his rent and to get a return on his investment based upon the rent. Well, if his taxes go up or his insurance goes up, those are usually the only two that are in the modified gross, then the tenant gets passed through only the increased portion. Then there's a net lease. The net lease, in addition to taxes and insurance, the operating expenses of the property get passed through to the tenant. And the operating expenses are usually taxes, the insurance from $1 in each case, as opposed to the landlord including the base year. Repairs, maintenance, could be replacement of things, staffing, something for management, a whole litany, and I'll show you some examples of the expenses that could go into that. And lastly, there's what's called a triple net lease. Now, I will tell you that these four, the triple net lease means that every expense possible gets passed through to the tenant. The difference really between a net lease and a triple net lease is that in a net lease, the landlord is going to be obligated to maintain the roof, the structure, maybe the driveways and parking areas, and everything else gets passed through in the way of operating expenses. The triple net, everything gets passed through 100%. Now, these terms, while they're thrown around in the business community, are very loosely defined. Because I've had people say, oh, it's a gross lease, or oh, it's a triple net lease. And then I start asking, because I have to write them. You know, what happens to me is, I get our friendly and helpful brokers that come to me with a lease, and they say, I need you to draft a triple net lease for me. Great. Is the tenant taking care of the roof? No, I'm taking care of the roof.
Right.
What about the driveway? No, I'll take care of the driveway. And the structure? Of course I'm gonna take care of the structure, it's my building. Okay, well, that's not a triple net lease. Oh, well, okay. Well, guess what your LOI is gonna say? Triple net lease. So, that's what happens, so it turns into confusion, it gets worked out.
What happens in that case if like as you said, the tenant, the owner is paying those things and there is a triple net lease and they're not supposed to? I mean, that's just extra money coming?
By the time it gets to hopefully by the time it gets to the lease, past that first discussion stage, you got it right.
Council got it.
Hopefully before it gets signed, we've asked enough of those questions back and forth, because usually the tenants, in a commercial, in this kind of a lease, like that kind of a lease we're going to look at, you're going to have lawyers on both sides and everybody's going to be reading things, and you're going to know what you have to pay and what you don't have to pay, okay? So, in either a shopping center or an office building, and I think it more applies in the office setting, is something called a load factor. The load factor is the difference between usable square footage and rentable square footage. Sounds like weird words. Usable square footage, very simply, is the inside of this box. This is what you can use. It's your office, your classroom, your store. This is the box that's usable. Without getting into ridiculous definitions, some places will define it to the wall. Some places will have, some definitions will take it to the middle of the wall between the two spaces.
Yeah, by use time.
It depends on what standards you're using.
Yeah.
As a practical matter, to avoid it getting crazy, because what happens with square footage is that you'll have a lease, you'll agree on square footage, and if you don't have the right wording in there, this helpful service will come along and call on the tenant and say, hello tenant, I have a helpful service, and I'm here because we don't think your landlord did a good job measuring your premises. So we're going to come in with our laser measurement tools, and we're going to see that if the number in the lease is the correct number, and if it's not, we're going to help you go back to your landlord and get your rent adjusted, and you're going to pay us a percentage of the savings. That's the helpful service. They're a royal pain from a landlord standpoint and from a lawyer standpoint. So the way to handle it is once you've agreed on a square footage, whether the usable square footage, you have a provision saying, landlord and tenant have agreed that the square footage of the premises is deemed to be X and is not subject to modification or remeasurement. That keeps the parties from getting into an argument. Now, that's usable. Rentable square footage. So the landlord has this beautiful building, and they want to get paid rent for the whole building. So when we go out that door, we're in a hallway, and there's a stairwell, and elevators, and restrooms, and walkways. Well, nobody's renting those from us as the landlord. So what happens is they do a mathematical calculation to find out the approximate square footage of those which are called common areas, because they're not part of any one tenant space, they're for the use of all the tenants. And that square footage gets calculated, and a factor, a load factor, gets applied to the usable square footage. Averaged in an office building, I would say, is maybe 12 to 15%. So then, you might have don't hold me to the math, please. You might have a 1,000 square foot space that turns into a 1,200 square foot rentable lease. And the tenant is paying rent on 1,200 square feet because that's what the agreement is, because the landlord wants to get paid for the whole building. Expenses. Expenses in a net lease or a net lease are things that get passed through to the tenant. I'm going to go through a list of what they could be. There are all the expenses involved in operating the property. Common area lighting, parking, maintenance, cleaning, security, and maybe even something for the landlord's offices. Included in there is maintenance. Maintenance is basically repair type of things, maintaining and repairing, making sure that the lights are working, that the bulbs need to be changed, that the doors are opening and closing, the elevators are working. It also includes repairs. If the door breaks and the handle is broken, the landlord hires somebody, they come out, they fix it, and it's an expense, it's a repair expense that gets passed through as part of the expense costs. The problem is repairs versus replacement. When something can no longer be repaired and it has to be replaced. My example of the door handle is nothing. It's $50. I heard it. Of course. It's the air conditioner. We live in South Florida. Air conditioner has a useful life of 7 years, let's say. And now you get into the argument of who's going to pay the cost of the replacement of the air conditioner. That's the big component that we always see. It could be smaller things, but I like to focus on that because it's so easy, and obviously it's fairly common. It gets into an analysis as to how long is the lease and who's bearing the risk, and it's simply an economic negotiation. I try and distinguish in the shorter the lease, the less burden should be on the tenant, because the longer the lease, the more the tenant is treated as being the owner of the property.
One question. So, I know it's common now for especially in office spaces where they rent out to various styles of companies. Like you could have for example, so where I get my lashes done, that she rents out a room, and then downstairs is a call center, and right underneath that, the floor down, it's nursing to some degree, it's some medical.
It's just a multi-tenant building.
So I'm talking about can you have different
uses?
Like you can have a gross lease and someone else can have a triple net.
Sure.
Can that change?
Sure.
Doesn't have to be
It's by contract.
the building.
Well, it's all economics.
Oh, okay.
It's all economics to the landlord. So take a situation, and I have clients do this all the time. Yes, it's very easy, because what happens is when you have empty space, you want to fill it.
Right.
Okay, so if you have empty space and you want $1,500 including the expenses, okay, and the tenant comes along and says, I don't want to pay your expenses, I'll give you $1,200.
Right.
You're going to take it. I mean, you're going to make a little less money than the other guy, but you're going to take it because the $1,200 is better than the empty.
Okay.
Now, if there's a lot of demand for the space, if it's a brand new shiny shopping center that's going up at University at 595, where everybody wants to be in that shopping center because the traffic count is ridiculously high, you're going to be able to demand whatever you want.
Okay.
You're also not going to get the lash place in there,
Right.
because they're not going to want to pay that kind of rent.
Right.
The per square foot rent is going to reflect it, and the expense is going to reflect it. Downtown office building, we talked about earlier, we mentioned about the cranes. I don't know if that was just before class started, talking about all the cranes in the downtown area. There's an office building that Stiles is building right in the downtown, in the core, and I think with base rent and expenses, they're charging, I think, $60 a foot all in, maybe $65 a foot. That's pretty heavy. Those of you that are in that business, it's a brand new building. It's right there it's going to be on 3rd Avenue, just off Las Olas, so it's prime real estate, but it's still expensive. There's all kinds of factors that do that. So you got to be careful about replacement. Shorter term, you're going to fight more. Longer term, it's going to be a cost of doing business, and it's strictly a negotiation. Another provision we're going to see, and I'm going to get into the actual lease itself in just a minute, is governmental requirements. Now it sounds pretty innocuous, and you'll see the language looks pretty innocuous, that the tenant's going to comply with governmental requirements. They're going to comply with all rules, regulations, orders, codes, and other things like that to comply with governmental requirements. Seems pretty normal, seems pretty easy, the kind of thing that you would say tenants shouldn't have a problem with. Until we get to the situation where the municipality, the county, passes an ordinance that says that all schools must have sprinklers. I'm using the sprinklers as an old example because almost everybody's got sprinklers now. But this was the headache for a long time, was when they started adding to the fire codes the sprinklers. And there was a provision that if you did a certain amount of renovation, or you changed the use, or you had to upgrade the building and put this in. This is called a capital improvement. Capital improvement is like an add-on to the building. You are building something to the landlord's building. And therefore, I try when I'm representing a tenant, and really it's not fair to impose, unless it's a long-term, like a ground lease, or a 25-year triple net lease or something like that, the obligation to make this kind of improvement should stay with the landlord because it stays with the building, it's permanent, and it really improves the landlord's building as opposed to providing a benefit for the tenant.
But if it is a long-term lease, like a 25, 30-year lease, let's say with the government, it can be passed on to the tenant.
Yes, but the government is a bad example because the government has special leases and special forms that let them get out of the lease on short notice.
Yeah.
It's true. I mean, it happens to be a fact of life. So when you're doing a lease, because you do a lease, let's say to the state of Florida for, it used to be called Department of Family Services, that had this situation. They have a provision in every one of their leases that says that if their agency is not renewed for funding, that they have the right to terminate the lease at the end of the year. So you may think you have a 15-year lease, but down there in the fine print, they can terminate at the end of any year when they don't get their funding. And that scares the daylights out of banks.
Yeah, I just got an RFP from the IRS for a building that I manage.
An RFP from the IRS? That
And I'm
sounds scary.
like, and now you're saying that, I'm like, wow, okay.
Oh, you
So
can see
that's
that. Well, yeah, okay, but
I just got
so
it
hold on. Let me tell
Friday,
you
so
something.
I haven't.
What you're going to get from GSA is going to be something that's going to say, because they're not going to forget the political thing about the government shutting down and all that stuff. The IRS is not going to get defunded.
Yeah.
It's not going to happen. The taxes aren't going to go away. However, the other part of the clause that you're usually going to see is if a government-owned building becomes vacant within a radius, 10 miles, 5 miles, something like that. So the IRS for years has been at the corner of University and Broward back in there. That was a private office complex once upon a time that they acquired. So that's if that, and I don't know for a fact, but if that's a government-owned facility and some agency contracts or moves out or something like that, and now they have an extra 5,000 square foot of empty space, and there's another agency in your building 3 miles away, you may have a clause in your lease that says, if that space becomes open in that governmental building, we have the right to cancel your lease and move there. And that becomes a risk, and the biggest, forget the business risk to the landlord, go get financing on that, good luck. It's tough. It doesn't happen very often.
I was telling you earlier that I wrote leases for the government overseas, and I wrote a 9-year lease and canceled it in a month. And the reason was because the people who moved in there didn't like it. That's all it took. Move right out. But that's overseas.
Have you ever done that? I'm just saying, have you ever done that domestically?
Never.
Not that close, okay.
No, never.
I wouldn't think so. Taxes. Taxes is another pass-through. Taxes is a pass-through. Real estate taxes. In a triple net lease or a true net lease, taxes gets passed through. The modified gross, only the increase in real estate taxes over the base year. But taxes can be subject to definition, because what happens if there's an assessment to repave the roads in the neighborhood? And instead of it just being your regular ad valorem taxes, which are taxes based upon the value of the property, they come along and they pass an assessment that says everybody in this neighborhood has to pay X thousands of dollars per property to repave the entry roads and to put new striping and curbing and things like that. So that assessment comes along, and it's unusual in terms of its size. If the lease is improperly worded, and it says just If it just says real estate taxes, that may not be included, it may not get passed through. If it says taxes and assessments, it's going to get passed through, but if the landlord has an option, which most of these assessments do, where you pay it up front in a lump sum, or you pay it over 5 years, and the landlord just happens to have cash around that year, and they pay it in a lump sum, without some protection to the tenant, that could get, all of a sudden that tenant could get a huge surprise bill for that assessment. Sales tax. In the state of Florida, and again, a lot of the stuff that I talk about is necessarily state-based. In the state of Florida, rent is subject to sales tax. They've reduced the sales tax on rent. It is 3 basis points lower than the regular sales tax rate. So if it's 7% with the new penny sales tax in there, then it's 667, I believe. Or 6.7. Yeah, right. So it's 30 basis points. 0.3%. The basis points. Let Dr. Forkey talk about basis points. Sales tax is due on rent. However, beware. What is rent? Rent, for purposes of sales tax, is everything that the tenant pays that is normally the expense of the landlord. Base rent is clearly subject to sales tax. Real estate taxes are imposed on the landlord. They're passed through to the tenant by contract. You have to pay sales tax on the real estate taxes that the tenant is paying to the landlord because it's additional rent. All the operating expenses, which the tenant is basically reimbursing the landlord for, is additional rent. In a lease, you'll see that all of these things are called additional rent for the purposes of collection, because rent is subject to the 3-day notice and the eviction and all those things. So as you define all of these things as rent, it's all under the same category as base rent for purposes of collection. It's also under the same category for late charges, which we're going to talk about in a minute. Questions? Okay, so let's look at some specifics. Forgive me for sitting and looking at the document here. So, what I'm going to show you is my beloved commercial lease. This is my base lease form. And I say that because this is a form upon which I keep a clause bank. And I actually have some other clauses that I put onto Canvas, or some that I'm going to show you from the emails maybe, that are used to customize the base lease. But for the starters, I'm going to go through and tell you what the things do and what they mean. So you'll see the parties, that's fairly simple. Remember I cautioned you when we were talking about conveyances that it's very simple using the internet to find out who owns something. So you really kind of need, it's smart to know to do some checking, especially on a longer term lease, to find out if the party that's represented to you to be the landlord is the landlord. Do they own this property? Do they have the right to lease you this property? Because typically in a commercial setting, the tenant's going to make an investment to move into this space. Similarly, the landlord wants to know who the tenant is in terms of do they have the ability to perform the lease. That's usually credit checking and something about the tenant's history. Sometimes it's a new entity, sometimes it's not. So the definition of the premises, this one's fairly simple. This is talking about either an office or retail. It's approximately so many rentable square feet in a building, and it's defined by street address. If you're talking about an entire building, typically I would put a legal description in there. But for purposes of most office or space leases, an address will do. Sometimes in an office you're going to put your suite number. In a shopping center they use bay numbers. Some shopping centers use the street address to identify the particular bay. So you're defining the premises. An out parcel of a shopping center, you've all seen places where there might be a small restaurant or a bank or a gas station just sitting out close to the road away from the rest of the shopping center. That's called an out parcel. that's defined on a site plan or some other way to describe it.
I have a question.
Yes,
If a tenant or an owner, landlord, writes something after the attorney drafted the contract, as long as both parties initial, is that allowed?
yes.
So,
That's how it gets screwed up. Yes, happens all the time.
okay, but, so if a landlord really wants to add something in there and the tenant agrees to it, there's no
I would
date.
say most of the time, that change is going to be a number. It's not going to be a clause. Sometimes it's a clause, but it's usually a number. It might be some little thing saying that, unusual, because usually it would be in there, but they could say tenant gets 2 months free rent.
Right.
But usually we're going to have that drafted, and we're going to know that in advance. But that business term, if a business term is changing prior to the lease starting or being signed, they can handwrite that in if it's small enough. Or they'll call me and say, change such and such. They do it. In this particular lease form, the rentable square footage of the premises is calculated, they define it, from the outside of the exterior wall of the premises or exterior wall bordering the common area to the midpoint. This is a little more technical than some, and it doesn't have, so it's carefully defined how it happened. I don't like that because, again, it's opening up a question of measurement. So the next sentence in there says that they're accepting it, including the square footage, even if the actual number of square foot differs. See that at the bottom here? Right in here? So you're agreeing that you're not going to remeasure it. Term is fairly simple, although the commencement date is usually, it could be in the middle of the month. It happens all the time. You make a deal, today's the 9th, and we sign the lease and turn the keys over to the tenant. It's supposed to be a 5-year deal. So here you'll see it says blank years plus the number of days from the commencement date to the beginning of the first calendar month. That takes care of the extra month. Paragraph 4, base rent. Fairly easy. Sometimes it's stated as total, if you have a fixed rent for the term of the lease. Sometimes in this particular one, it's initial annual rent, because it's going to be subject to adjustment. And we also say plus tax, payable monthly installments. And then it goes on to say when it's due, and it talks about additional rent. Additional rent is payable in addition to base rent, and it's all subject to sales tax. Then there's usually an upfront payment. We have an acknowledgement there. And then the next little paragraph at the bottom of page 1 is where we say, you're going to pay it to the landlord at the address we give you. And if you don't pay it by the 10th, we're going to have a late charge of 5% of the amount due. Here's that compliance of laws provision that I was talking about, where it says what the tenant's going to do. By the way, I have this up here, but you have this on Canvas, so you can read this at your leisure. If you have any questions about it, I'm certainly happy to go over it.
Before you go on any further, I mean, that previous paragraph right there about when the rent is due.
Yes.
That totally exceeds the 3 days not paying it.
Because this is the grace period we're talking about.
Yeah.
It tends a little long, but some landlords are more liberal than others. So they're giving you 10 years, because some landlords take the position that you're really going to only be late once, okay? Because even if you consistently pay on the 10th of the month or the 9th of the month, that check's coming 30 days apart.
Yeah.
Okay? You can't stretch it. It's not 9 days this month and then 18 days next month. You'll see that a little further down in the lease when we get to defaults. So some landlords just don't want to bust their tenants' chops for 3 days.
But if you have this in there, then you basically you waive your right to the 3-day.
No, it's not technically, well, this is the late fee. This is not the default. The default's further back, but it's probably 10 days there too.
Okay.
The 3 days, in that case, it's not a 3-day notice.
Yeah.
Maybe it's a 10-day notice. We'll stay tuned, and we'll get there a little further down the lease. Here's the compliance of laws. And one of the things that's important in the compliance of laws here, and you'll see in the last 3 lines, is where it talks about where the tenant's going to do all these things. Then it's going to say including but not limited to making non-structural modifications. That's an important concept, non-structural. Non-structural modifications to the premises to comply with state or federal laws or regulations affecting the accessibility of the premises for disabled persons. You may know that as the ADA, the Americans with Disabilities Act. So, in talking about, this is where it turns on litigation versus non-litigation, because it happens all the time. You have somebody that comes in and says, the premises are not in compliance, I can't get in, I'm in a wheelchair. I actually, when I first started, I had a partner who had polio when he was a young man in the 50s and practiced his entire life in a wheelchair. And when he retired, he liked to go to restaurants, he liked to go to theater, and you know, there were people that were doing this to make trouble. He was doing it for real, because he was in a wheelchair and he couldn't get into the theater. And if he got into the theater, he had to sit in crappy, you know, up in the back rows, and he couldn't get into his favorite restaurants because there were steps and things like that. So he started doing it for reality, for a real reason. There are people who will come out there, and it's a cottage industry. It's more than a cottage industry. There are people that will actually go out there and deliberately look for problems like this and try and make money off of it. And the lawyers will make money, the plaintiffs will make money, and all they're doing is, so the allocation of responsibility is, here we talk about non-structural in this clause. It's important. Non-structural would mean, for example, you come in here, I'm going to use my favorite example, which is the classroom. So it's the obligation of the tenant to move the desks around. If you have, if it's determined that the path of travel within the classroom is insufficient for someone to get to a seat. Now, it's not improper to say that the seats closest to the door, you take chairs away, you move a table, and you provide handicapped access there. You don't have to rearrange the whole classroom. But inside, moving things around, whether it's interior partitions and workstations, desks and chairs, whatever it is, display cases in a retail store, those are interior, non-structural modifications. As opposed to, the door is not, I think it's 36 inches is the requirement, the restrooms don't have the appropriate, those are big bucks to change them out. There's ramps in the parking lot. Those should properly all be the obligation of the landlord, except when you have a situation where it is a single tenant triple net lease where you dump everything to the tenant. Everything, and you make it very clear in the lease that the tenant is obligated for the roof, the structure, the ADA compliance, the air conditioning replacement, 100%. Don't call me for 20 years. Pay the rent, I don't want to know about it. In that case, everything goes over to the tenant. Risk of loss. Risk of loss, basically the tenant is saying that, in this case, the landlord is saying, whatever you bring in here, whatever furniture, equipment, inventory, I'm not responsible if something breaks. Now, this is going to, it's usually an exculpation so that the landlord is not responsible if another tenant does something or a contractor does something. If the landlord is outright negligent, then it's going to be very hard to get around that obligation. And in fact, if I'm on the tenant's side, I'm going to have a provision in there that's going to say, except for the negligence of the landlord or the landlord's contractors or agents.
So then this basic one is more from the landlord perspective.
Guilty.
Okay.
Yep. Landlords pay better fees. No. It's
No, fair.
From a drafting standpoint, for the most part, you're drafting for the landlord.
Yeah.
Reviewing for the tenant. Security deposit. I talked about the security deposit in the residential setting where it's regulated. In the commercial setting, it's not regulated. So if you read this, you'll see it's there to secure the faithful performance of all the terms and conditions of the lease. That's why it's there. Then the very next sentence says that the landlord's not obligated to apply it to arrears. It's an option, but they're not obligated. So it's no defense to non-payment of rent for the tenant to say to the landlord, hey, you can't sue me for that I missed a month's rent, you have a security deposit. No, this clause, and again, this is an agreement by contract. You can't, okay? And the next sentence is kind of clear. Application of the security deposit shall be at the sole option of the landlord. Then it goes on, possession of not. Security deposit is to return to tenant when the lease is terminated, if not otherwise applied. Well, it doesn't say within 15 days or 20 days or 30 days. It doesn't say anything. So the law would say a reasonable time. If I'm representing a tenant, I'm going to stick a number of days in there, maybe 30 days. So give the landlord a time, he's got to get the money back to you. Some landlords, so you get they'll say 60 days, that's too long. I think it's too long anyway. Then there's other provisions, you don't have a right to it back until you're out. There's also, here's the provision that says if there's a default, then the landlord can apply the security deposit on all damages. And finally, at the end of this paragraph, it specifically says, which is perfectly okay in commercial, that the landlord is not obligated to hold the security deposit in a separate fund. That's a big difference from residential. The little paragraph that follows it is a restatement of the statutory landlord's lien, and basically says this for further security, we're pledging all our fixtures and such.
Do they have to open, on the residential side in the state, do they have to open per, like, one separate account where you put all of your deposits, or is it per deposit you add an account?
I think if you have a big enough building, you can have one account. Okay. 8, taxes and insurance. Taxes and utility expenses in paragraph 8 are not reimbursement expenses. This is just a statement that the tenant agrees that they're going to pay FP&L, pay for their phone, pay for their data, pay for their garbage, pay whatever expenses they're going to make. They're going to keep their own obligations current. Paragraph 9 is the pass-through of expenses. So here it talks about common expenses. You may hear the word CAM used. CAM is usually common area maintenance. That's down in C. Unfortunately, what you will see in a lot of leases is you'll see CAM defined to include not only the maintenance but the taxes and insurance. I usually keep them separate and I label it as common expenses because they are different concepts. And they're, like I said, in the modified gross, the paragraph C wouldn't be in there. Also in the modified gross, we would have a provision up in the intro. Instead of just saying shall pay as additional rent tenants pro rata share of common expenses, I would add in excess of the amounts payable for 2019, the base year.
So operationally, under like the different lease types by deal type, where do you place CAM? Like
that would be in a net lease.
That's your net lease.
That's your net lease.
Okay.
Because all the expenses, in the net lease, all the expenses are passed through. Except maybe roof and structure, but we'll get there in a minute. Here you see a long definition of real estate taxes to try and cover all the things you can possibly think of. Insurance pass-through. Remember, in South Florida, you're going to have to get hit with windstorm insurance and probably flood insurance that should be laid out properly. The common area maintenance provision in this lease is relatively simple. It's kind of like catch-all and basically says everything. You'll see in shopping center leases, it's much more extensive than that because they want more detail and the tenant wants more exclusions. Here, D defines the common areas. Okay, E. So, we don't want to have a situation where these expenses accumulate. You know, as you've seen in some of your business models maybe, it costs a lot of money to operate a building. So tenant, you don't want to hit the tenant at the end of the year with a giant bill for all of the operating expenses, pro rata share of all the operating expenses. I glossed over something, I'll come back to it in a second. So what this provides is that the landlord creates a budget. And based upon the budget, usually the budget is based on prior year's expenses, the landlord charges 1/12 of the annual maintenance or common expense budget with each payment of base rent. And it's at the end of the year, you do a true-up or an adjustment that says, okay, we're going to compare what we charged you based on the budget, compare it to actual, and we'll send you a bill and you give us a difference. Practice tip / protection for the tenant again. if the landlord's a bad estimator, and that differential at the end of the year is huge. Remember, you got a tenant that's operating a business, and again, I'm going to take the small business approach to it. And all of a sudden, let's say that we go to our $1,200 a month rent that I was using as an example before. And now, the operating expense adjustment comes in, and the landlord sends the tenant a $5,000 bill. A tenant that's operating and paying $1,200 in rent, he's going to have a huge budget issue with a $5,000 invoice. Tenant side protection, put in a provision that says if the operating expense catch-up is greater than 3 times the monthly rent or twice the monthly rent, the tenant will have an option of paying it over 3 months. I can usually get away with that, so you don't kill the tenant. I did gloss over something, and I apologize. I want to back up for a second, because in the lead paragraph of paragraph 9, it says tenant's pro rata share of common expenses. That's important, because there's a definition in there. Definition defines pro rata share as being a fraction, the numerator of which shall be the rentable square feet of the premises, and the denominator of which shall be the total rentable square feet of the property. We just settled the case in the office where there was an argument because there was a parking garage, and one of the tenants was complaining that the parking garage was not being included in the rentable square footage for purposes of assessing the expenses. In reality, the parking garage was being used by all the other tenants, but there was a lease to a municipality to authorize them to use it for special events and emergency parking, and so there was some rent being paid, and they were claiming that there should have been an increase in the denominator for the square footage of the parking garage, which is actually a very ridiculous position, and that should be considered the same as any of the spaces in the shopping center. So what you'll see in very sophisticated leases and shopping center leases, take like the Broward Mall or Galleria or any of those places, you look at them, and very often a store like Macy's will actually own its store and the land under it. So you will find exclusions, or maybe they have a separate tax bill even if they're a tenant. You'll find exclusions. Maybe an out parcel will have a separate tax bill. So they'll have a definition saying that you're changing the denominator, or saying that it won't include this and it won't include that. Depends. It all depends upon the improvement. This is where we're wide open for negotiation. Use clause is fairly straightforward, but again, in retail, it can be very narrowly defined because you have to preserve your tenant mix. Then you start to get into, and I'm not going to go too deep into exclusives, but you can get into situations where you got one guy, perfect example, we ground leased a piece to a Pollo Tropical. We have another piece of property next to it. Part of the deal with the Pollo Tropical was we can't lease to another restaurant that sells chicken and maybe other things. Did I talk about the deed restrictions for the McDonald's piece?
Yeah.
So it's the same concept. They're looking to prevent competition. The one that causes heartburn, figuratively, not necessarily literally, to almost every landlord in a shopping center is the food court. Because everybody wants to sell the French fries. And everybody wants exclusives. And then you get the, who can sell what, and that's always the hardest thing. You have grocery stores that don't want the dollar store, because I guess the dollar store sells certain food items. So the Save-A-Lot next door wants to prohibit the dollar store from competing. So then you get into a compromise situation that they can sell certain kinds of groceries, but not meats, not anything out of the freezer, or other kinds of restrictions for uses and exclusives, that the second place can't sell more than 20% of the same product. And that can be either by sales, sometimes it's floor area, all kinds of things. Walgreens will go in and they'll restrict liquor sales. Pizza Hut will restrict pizza, but then what happens if you put a sit-down Italian restaurant in there? Yes?
The property owner that taught me a lot of stuff, he said to me that as a landlord, is it really in his interest if he puts someone as a competitor next to someone who's currently paying him rent? Because if he has a competitor, now he's putting him out of business. So that clause actually makes sense to him, because to restrict the usage. In his plaza, he only wants one exercise or two exercises places that are totally different. So he wouldn't necessarily inhibit the ability of the business to make money, because he feels if I put something that's like you, I lose money.
Let's play.
What's it worth to him?
Let's play, okay? What's an exercise place?
Right now, a yoga studio.
Oh, can I put a crunch gym next to it?
Nope. He doesn't want a crunch gym.
No, forget him. Let's talk about exclusives for a minute.
Okay.
You said exercise place.
Yeah.
Okay?
Yeah.
That could be your definition?
No, that's not gonna be my definition. He has specific definitions, he's a lawyer. I just follow what he already
Okay,
has.
but let's talk about this, and please jump in, anybody. So, I'm gonna give you examples. It's stuff like that that causes the conflicts in shopping centers because of the definitions, and because of the yoga studio is really narrow.
Yeah.
Hold on. Yeah.
I have a public shopping center, and Publix, they restrict like deli, bakery, but then they'll allow you to have a
Subway.
Yeah.
Yep.
But I had a pastry shop, and the only way they would allow them to go in there is if only a small percentage came from like a certain type of pastry, I think it was. And then they wouldn't allow a flower shop to go in there, nor pharmacists, because they have a pharmacy in place. So.
So, a couple of things about that, and it's a great example. The thinking is that if you're gonna go into Publix and spend $12 or $13 on a Boar's Head sub, you're not a Subway customer.
Right.
And the Subway customer is gonna get the $5 football one, is not gonna come spend the $15 on the Publix sub. So they don't care. They'll let the Subway go in there. Once upon a time, what you used to have was, you always had it in the older shopping centers, and you'll see the boxes in the older centers are still left over. You'd have the grocery store here, and immediately next door was the drugstore.
Yeah.
It was the Publix and the Eckers, and they were next to each other, and neither competed. One was the pharmacy, the drugstore, one was the grocery store.
Yeah.
And then the supermarkets started to expand. And then the CVS's and the Walgreens decided they didn't want to be in line anymore. You know why they didn't want to be in line? You know the most important thing to them? What?
Beer?
So she said speed.
What do you think is the most important thing for the placement of the drugstores nowadays?
Drive-through.
I heard it.
Visibility and traffic.
Drive-through.
It's a drive-through. I mean, we actually went through one on Sterling Road where the client cannibalized a bunch of small tenants, moved them to other parts of the center so that they could expand the Walgreens, because there was an inline Walgreens, and expand them so they could put a drive-through on the back wall.
Yeah.
It was the only way to keep them. Because when you know, mom has been to the pediatrician, got the sick kid in the car, or even if the adult is sick, and the doctor calls in that prescription, you don't want to get out of the car and go into the drugstore, you want to pull into the drive-through. And so that's why they're all by themselves on the corner with the big drive-through lanes and all that stuff. So the Publix is a great example for that kind of stuff. So that whole model changed when the grocery stores expanded. And Publix, of course, is, you know, everybody wants a Publix. Everybody's willing to put up with the Publix restrictions because they're a great tenant and they draw all kinds of traffic to the shopping center. The one I was starting to allude to before was like the Pizza Hut, and the Pizza Hut restriction that you can't have other pizza restaurants. But we negotiated an exception for a real sit-down Italian restaurant with table service, not takeout, and no more than, take a number, 5, 10, 15% pizza sales, because you can't not let them do that.
Do you negotiate that after the pizza tenant's already in the shopping center?
No.
Before?
It's part of their lease, because they'll come to you, especially, Pizza Hut's a good example, it's a national chain. Even though most shopping centers have their form of lease that they use, When a national tenant comes in, they're gonna present you with their form. Because they have, you have one shopping center, or maybe you have a chain of shopping centers, but they have 1,000 stores. They have to use the same lease. They insist on using the same lease. And you want them because they're a good credit tenant. So you negotiate those kinds of things. There's all kinds of stuff like that. But back to the exercise facility. I mean, it's important. You happen to hit a really good example because of the internet. If you think about it, shopping centers are getting murdered these days because everybody's buying things online.
Yep.
I'm sorry, it's an unfair advantage, but I needed some mailing labels or something like that. And I went online to look at what Office Depot was selling them for, and they had a package of 50 Avery labels for $19. I went on Amazon, and the same Avery label, the same package, was $9 with free shipping. Why would I bother? What's the point? I didn't need them today. If I needed them today, it's different. But it's almost unfair to the big box, to the box stores. So what happens is the landlords are trying to protect. What's that?
Unfair?
How's that unfair?
Whatever. It's
capitalism.
Exactly. That sounds better.
Change their business structure.
They need to change the business structure to match the competition.
It's not fair to keeping other.
So now let's rewind and look at my example. I'm focusing on the shopping center.
Okay.
And I'm not coming away from your exercise example because I want to tell you what's been done. So where it used to be that you would go to a shopping center and you'd have all these retailers that would be selling clothing and shoes and whatever the products were that you needed, and you'd go in there. Now it's just as easy to go on the computer and find the stuff. Because they don't care. You're going to say, well, I want to try my shoes on. They don't care because the retailers will say if you don't like them, send them back. And they'll even give you a mailing label to send it back. My daughter told me she went into one of the big boxes, the big box shoe stores and saw this. No, it wasn't DSW. It happened not to have been DSW. Whatever it was one of the big boxes, or a sporting goods store. I think she was looking for sneakers. So it could have been,
Dick's or something like that.
They're gone, right? They're gone. But something like that.
Sportatory Dick's.
She couldn't find anyone who would give her any help.
Yep.
She tried, she was looking for help, she wanted a particular size, a particular color, and the people were like walking around in a daze, and no one bothered. She said, screw this. Order. Done. So, why am I going off on this side tangent? Exercise. I'm coming back to your exercise example. So I have a client who bought a really crappy shopping center with maybe a 30% occupancy rate when he bought it. And he bought it from a bank several years back when the bank had foreclosed and taken it back. In the middle of the shopping center was a 50,000 square foot hole that had been a Winn-Dixie. Now, Winn-Dixie has contracted. They went through a bankruptcy, at least one, maybe two. No, for real.
Yeah.
For real. They've done this more than once.
Oh my God.
And they have abandoned stores. On the flip side, I don't know if you know, there's one out here on State Road 84 at Hiatus, where they completely renovated and built a beautiful Winn-Dixie there. That's a really nice store. Now,
the one on Federal 2
and
Fort Lauderdale.
Where?
It's between
Sunrise and Broward Boulevard.
Broward, yeah.
Yeah, I know that one.
Yeah, but that hasn't been renovated.
No,
it hasn't.
No. Well, there's also one down by 17th Street.
There's one in Miami too, and
No,
I'm
they're
there.
all over the place. They're all over the place, but those are old stores.
Yeah.
Now, the one you're talking about, the one that's, I know exactly, like 6th. Yeah, it's at 6th and Broward, 6th and Federal.
Yeah.
But that's an old, and maybe they have a long-term lease, and maybe they decided they wanted to be in that market, and maybe it's because you have to go another 10 minutes to get to the Publix, and so they're serving, although I know people who say, oh my God, I wouldn't go into a Winn-Dixie, I'm a Publix shopper. It's people, it's just, it's different. They have different products, they have different clientele. So this space was a 50,000 square foot empty in the middle of this shopping center, and there were other spaces that were empty. And those of you that work in real estate, you know that's a big space. So the client started cleaning the place up, and the first thing he did was he took, I think it was originally a vacated post office at one end,